Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
We're getting commentary on his case. Dati mihi Anglican for his service Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Made it back from the post office just in time to be late. Sorry, I thought I was quicker than I was. I was riding my bike. So
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
there we go. There's that one. Seats should be working. Why are they not? Hang on. Let's fix the seats again. Okay, they should be working now. Fixed them. Everything's repaired. I single-handedly repaired every single one of your seats. There we go. Welcome, Cheryl. Cheryl won, by the way. Cheryl won. She won. I mean, Cheryl won is her name, but Cheryl also won on the First in Chat competition. So, Cheryl, congratulations. You are, in fact, first in chat. And as a result, you're going to be sentenced to internet ownership. This means that everything that was Jennifer's responsibility up till this moment is now your responsibility for the rest of the day and until we start again tomorrow morning. You get the overnight shift. Cheryl, you're going to do great. Congratulations. This goes on your permanent record. And we just are glad that it's not our responsibility anymore. So good riddance.
Hello.
Good riddance. Hello. Welcome. No, until Monday. Oh yeah, it's Friday. Sorry, Cheryl. You should have thought about that before you said, what'd you say in chat? S. Before you said S in chat. Should have thought about the weekend. Any plans you might have had. Past tense. Because we know what you're doing now. Peter's like, I want to be first. It's rigged. I saw that. Can I be first? So yes, the weekend shift. Jennifer says good riddance as well. Yeah. All right. I don't know. It's a possibility we go live tomorrow. A couple things have to happen, first of all. I have to call the shop where Mrs. R.A.'s car is and say, did he fix the whole engine thing? And if they did, we have to go pick it up. And if we get to pick it up, then I think I have to drive an hour and a half and possibly metal detecting. Might be live for some metal detecting, but it's looking like a slim thing. They were supposed to text us back this morning, and they did not. So I'm thinking the car is still being fixed.
You don't put a diplomatic plate on a hoopty.
Got to get the big car working so the door can go to the shop. That's the whole idea. The beach, the metal detecting. The door was going to be the excuse to go metal detecting. Need good thoughts. My flight is on time Sunday. I have wonderful crews, and I'm worried about the flights. Tammy, oh, man, I know that flights are a little iffy right now, but I think you're going to be all right. I think I've got a good feeling about this, Tammy. Looking forward to your amazing cruise. Hopefully that works out for you wonderfully. And do take pictures and tell us all about it when you get back. Let's see. I went to the post office. I got 2 things, and I don't know which one I'm supposed to open live on the air. I've got one that is big and heavy and is ticking. Well, maybe that's just my ears. I can't tell if it's ticking or not. And I got one that's smaller and light and also is not ticking. So both. It looks like both of them came from Amazon, so I can't even see what. Don't open the ticking one. You guys ready for some ASMR? Oh, this one's from Josh. Josh says the small one's mine. Josh sends us another goat, a screaming goat, which is not just a normal screaming goat. This is the Halloween edition. We are slowly building up the collection. Somewhere, I have a regular screaming goat, which I think my kids run off with. I have the Christmas screaming goat, and now I have the screaming Halloween goat. Josh, thank you, my friend. Thank you. I assume it makes the same noise. I have to get a sharp object to open that up. It'll be good for the Halloween stream. Yes, next year. But I've been using the Christmas one all year, so I think I can use it anytime. Play it. It makes the same sound. It's just louder. Sharp object acquired. Let's see. It looks very similar. Only it's standing on a pumpkin. Screaming goats only make one. Oh, it's out. It's out of the package. There's the ownership book, which comes with every goat. Okay, we pull the tab. We hold it right up to the microphone. We crank up the sensitivity on the mic for a minute. First of all, here's one. That's the Christmas goat. Here's the Halloween goats. It doesn't work, Josh. So it's the scream with the organ from the Addams Family. It's a bit of a. I'm glad it only plays that much of the song so we don't get copyright strikes every time we play it. Josh, I like that. That's a great addition. There will be times when that will be the perfect sound to play. We must always use that one. I'm thinking this one is not a goat, and now I don't know who sent this one. I can put a link to the Halloween goat for those of you who are looking for it. Just one second. Halloween screaming goat. There we go. There's the Halloween Screaming Goat edition right there. And the lawyers make me say that that is, in fact, an affiliate link. And if you do, click on that link and make a purchase on Amazon. Amazon will reward me a small token, which will not cost you any more. But as an appreciation for me sending them a customer, they will give me a small incentive. At least that's the idea. And feel free to use that link prior to shopping on Amazon anytime, because it actually will give me the incentive if you buy other things as well. I love how Amazon sends the garbage from the packaging with your package. That's how you know that they're efficient. They don't even build up garbage from packaging things. This is a package within a package. So now I'm curious, because that was an Amazon package, but now here is another package that was shipped to Amazon from Denver. It's heavy. We use another word just besides package. Box. This is a box within a bag, if that works. Open it slowly. Discover the unexpectedly craveable taste of Dixie Grace's boiled peanuts. There's a national calendar for boiled peanuts. Modern twist on an iconic snack. There is a daisy. Or wait, that's a sunflower, I think. I think that's a sunflower. There's a whole ton of confetti. Like lots and lots of confetti. Which is exciting. My kids are going to spread that around the house later. And we have in here Dixie Grace's artisanal boiled peanuts. The original organic vegan and plant-based protein. And there's a second bag that's a different color. Who sent this? Who is this from? Can we say nuts? This is hot and spicy boiled peanuts. I like it. And I don't know what these are. There's a whole bunch of, there's still a fair amount of weight in the package. I thought this was just padding. But there's confetti paper. By the way, we're on verdict watch still. Nothing's happened. And within that, maybe this is where the ticking was coming from. It's like a little mini stick of dynamite. Oh, there's a jar in here. Oh, this is honey garlic boiled peanut topper. Whoa! I've got a whole selection of boiled peanut toppers. There's like seasonings. This one is sweet chili goji berry boiled peanut drizzle. Guess you can use a topper and a drizzle together. Oh, this packaging is unbelievable. This is like a whole experience. I should have not eaten lunch right before this, because now I have to wait for dinner. Burning hot. Just burning hot. Holy smokes, guys. Who sent this? Who sent this to me? It doesn't say inside. Oh, this is another drizzle. Bacon, chipotle, honey mustard. I don't know how they fit all this in here. You have to give it at least a taste of everything. Brown sugar bourbon. Ooh. That's a nice little seasoning. The last one is everything bagel. Peanut topper. Wow. Wow. There's a National Peanut Day. I don't know how to fit this all back in. This is organic, vegan, 7 grams of protein, gluten-free, non-GMO, shelf-stable, woman-owned, minority-owned, and made in the USA. I think they checked all the boxes. If they pay any taxes this year, they're doing something wrong. That is impressive. That is impressive. It says it shipped from Nicole. Is it Nicole? But I'm not sure if Nicole was like the person who owns the company or not. Wow. Thank you. Thank you, thank you. That came with the flour as well. Love the companies that put a lot of work into their packaging. It makes a difference to me. Shows they take pride in their products. Those peanuts were very nicely packaged, including the flour. Yes, this I believe is a sunflower. So that is really cool. Laurie, who sent these to me? Boiled peanuts are moist, where roasted are dry, or swampy, depending on your lingo. I believe these are swampy. They're in an airtight, sealed. If you were in Brazil and there was no name I would not eat, it may be poisonous. Oh, we're not in Brazil, luckily. This is made in the USA by non-GMO, everything else. I'm excited. I'm excited to try these out. Did the goat come with a 48-page mini book? It did. Right here. Featuring Halloween stories told with goat costume ideas and full-color illustrations. Yes, it did. Meet the Halloween goats, zombie goat, Franken goat, pumpkin goat. I think how to dress a goat for Halloween. Choose the perfect costume. Ready, set, goat. How to throw a goat themed Halloween party. Candy, 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 and other food too. I'm excited. Good reading there and good eating. Thank you, both of you, Josh, and whoever it was who sent me the boiled peanuts with all the seasonings. I'm super stoked. That's awesome. That's really cool. My garbage is now full, by the way. There's a Halloween goat, Polymac. We posted a link right here in chat for it. It looks like this. Let me go full screen on this one. It looks like this. In focus. Oh, it's green. You can't see it. And it sounds like this. Sounds beautiful. Great speaker quality on that one. You got to want it, though. I've got to figure out if it's where the button is. You can't push its back because it's like it just squats down if you do that. I think you have to push the pumpkin. All right. There's some action in court, which is good. Let's see if we can see what's happening here. Some people walking around. Maybe. Possibly. See if we have a question or something else from the jury. All right. Not seeing any announcements yet from the interwebs about it. The tune is Staccata in Fugue by John Sebastian Bach. Okay, then it's out of copyright. It's out of copyright. I should be fine playing it. Lunch is finished now. Verdict should be soon. Let's see. Not seen any updates from court. No indication there's been questions from the jury or anything. So let's see if we can do a little bit of court hopping while we wait and watch, because the timer, by the way, is all the way up to right here. Let's take the crop. Back it up and move it over so everything fits. You can see people walking around. That's what's got me hesitating a little bit. Sorry, Toccata and Fugue. It's iconic. That's what it is. Tom Brady cloned his dog with a blood sample. There's our deliberation timer. I'm just seeing if we can get any additional court happenings updated here. Let's see, what's this one? Oh, Judge this is landlord-tenant. It's Judge Middleton, landlord-tenant. Judge Dad was live. He doesn't appear to be live right now. Let's see if anybody else is actually live. Hey, Mrs. Ari.
Hey.
Judge Wolf is live.
Oh.
Let's see what he's doing. Super source. Box 4 is going to be 8. Why didn't that work? Why is this not working, guys?
Necessities for themselves or their families.
Now
That's the court's interpretation of the purpose of that. I do not find that to be applicable in this case. Number 11, the defendant argues that the defendant, although guilty of the crime, committed the offense under such unusual circumstances. It is unlikely that a sustained intent to violate the law motivated the criminal conduct. This court is of the opinion that this defendant's prior criminal record of burglary and theft do not make this an unusual circumstance that he's unlikely to have committed another crime. I think it is consistent with his prior pattern of behavior and criminal conduct. In addition to that, this is not one isolated knocking on the door to see if anyone's home or whatever he was doing, but rather is a pattern of the neighborhood of him going from house to house and trying to see if there was anyone home that he could, for whatever purpose. So it's not a situation where I think it's unlikely it was sustained intent to violate the law that motivated the criminal conduct. So I don't find that those things are applicable as well. That factor is applicable as well. And number 13, the basically catch-all. The court is well aware that, and I agree, I think Mr. McElhaney has a drug problem. And as a result of that, I think he is clearly has been in for many years suffering from a drug addiction, and for many years has been in need of treatment. The problem with that is that he has been given opportunity after opportunity, including the Hope Center, and has not taken advantage of any of those opportunities. It seems to me that despite having been available treatment options for him in the past, it's like he said himself, he just wasn't ready for it. And I have great respect for the Dixon County, or the 23rd Judicial Drug Court. I think they do a great work, and I think Mr. Barnhill is a very compassionate individual. His job is to try to see the good in people and to try to help them redeem themselves. My job is to not only try to judge people as far as whether or not they are credible, but also whether or not they are willing to and undergo a treatment that would help them, but also to balance that with the respect that I have to have for the protection of the society as a whole. So while I have great belief in the drug court program, the fact that this gentleman has been on probation over and over and over again is an indication to me that recalls the old saying that the definition of insanity is repeating the same thing over and over and over again and expecting a different result. I hope that Mr. McElhaney is serious about wanting to have treatment for his addiction, but this court is of the opinion that rendering him into the drug court program is not in the best interest of society and does not comply with what I believe the requirement of the law is. So therefore, as to count 1 of the aggravated burglary charge in docket number 134.
Thank you.
He is sentenced to serve the 10 years in the Tennessee Department of Corrections.
Ooh.
Count 1 of the 135, he is sentenced to 6 years for vehicular burglary and is ordered to serve that sentence, obviously contemporaneously with the 10-year sentence that I've previously indicated. Count 4, he is on the attempted burglary, he is sentenced to 10 years on the attempted burglary, which is a Class D felony, and court has ordered that be run. I mean, the agreement is that it's capped at 10 years for an aggregate sentence, so he is ordered to serve all of those as concurrently. and also concurrently with his Murray County. He'll get pre-sentence jail credits as set forth on the plea agreement until today.
10
That
years.
is the judgment of the court.
Your Honor, for his pre-sentence jail credits, that would be amended to reflect his time through today's hearing.
Yes,
I would think.
he'll get pre-sentence jail credits through today.
Yes, sir. Thank you.
All right.
130 MK.
All right, that
MKY.
concludes the cases that we have.
Thank you for the
today.
peanuts and the drizzles and the toppings, and I'm excited to try them.
All right. We'll go back to Mr. Lane's case.
Mr. Lane. Love Judge Wolf. Just a level-headed guy. Doesn't I don't think we've ever seen him riled up. Can't remember if we have, but
All right, Stephen P. Lane.
Stephen P. Step right up.
My understanding, Mr. Bellmeyer, is that you want to go ahead and arraign him on the violation of probation warrant. Is that correct?
That's correct, Your Honor. It's scheduled for Monday. Mr. Lane lives in Canyon County, so we just asked that if we could just go ahead and get his arraignment taken care of today.
All right. Do you know when is the VOP being set? If it's not on Monday, when would you, if he's arraigned on Monday, when would you be setting the VOP? Do you know? You can set it at the end of the month, and, I don't have to hear the violation of probation, I don't think.
Did you guys see the moon last night?
January 28th.
It's the closest it's been to the Earth since like 2019, so it was like a super moon. Apparently it looked bigger. I forgot to look, so I missed it. Judge Wolf is in Tennessee.
Thank you, Your Honor.
Bill Myers was shown as the attorney of record.
Thank you, Your Honor.
Thank you, Your Honor.
I'm trying to watch on the web for any rumors of motion in court. Let's see. Judge Wolf, are you done? Did you pause us? Or are you just very intently staring at I think he paused us. He's done. It's freeze frame court. That's what we're doing. Okay. Judge Wolf is done. Let's see if we have any others. Might pop into Judge Middleton's court really quickly just to see what's happening here.
Vermonter, we have to adjourn it and wait 10 more days. If you want to just dismiss it and then take possession of it on your own regard, that may make more sense. So, Mr. Bush, you just wish to dismiss?
I would ask Diana, is that agreeable with you to simply dismiss this and go from there?
That's fine.
All right.
Yes.
I mean, finding him is going to be difficult.
Well, Costa Rica is probably a good place to be in November, but I find
extradite.
Plaintiff moves to dismiss. Defendant has vacated. Yes. Well, if you wish to collect, Howard, maybe you can go down there and see if you can find him.
might be interesting.
Judge Welty was a big fan of Costa Rica. My sister lived there for several years.
Beautiful country.
I haven't been there, but I've been to an island about 50 miles away. All right. We'll call that a hearing with default and a motion to dismiss. And thank you. You're good to go.
Catherine, member for 21 months. OG.
Oh, Mr. Kreitz.
Sending left to Arian's
Your
fabulous
Honor.
mods.
How are we doing on Friday?
We're doing.
Thank you.
All right. All right, Mr. Bush, I'll remove you.
Mr. Bush gets the boot.
Jamie, apparently you've held on to John Bush for a little while longer, but there's some other options out there for you, I think, who would do good service for you. But I regret seeing John get out of the landlord-tenant business also. He does a good job in his cases, but I understand why he wants to pull back.
I'm trying to twist his arm, but I'd like to maybe get with you later on and find out who you suggest.
Well, I think John may have a couple of cases, and they're going to get back in the landlord-tenant business, and he might give you some advice on that.
Okay, thank you.
This is a termination of tenancy case, and we have service on both. This one is set for 1:35, so it's not for 9 minutes. So I'll put you both in the waiting room until somebody shows up. Have you sit here with me staring into space.
I missed the song of the day this morning, Judge, if you want to let us remind us
The
what
world's
that was.
most boringest live stream. All right, we got a little breathing room here.
Which we talk about.
What happened is some of the cases in the middle got settled. We had a 125, a 130. The 130 is done. 135, 145, 50, 55, 2. We're booked up until 2:45.
I think some of this peanut topping would be good on popcorn as well. Like burning hot. That sounds like a good one. I'm excited. Why is it a topping? It's a topper, so it's like a sprinkling across the top. Did the judge leave us as well? No, he's just reading. He's just a very good statue. Surprised we're all the way up to the hour and a half mark. Most of us thought this would be in under 2 hours. Easy decision. Jury was instructed by the judge, we didn't hear it, but she did instruct them that they could not make their decision based on sympathy for the defendant. But there was sort of an element of that in the defense case where they said basically just how young they were and how it destroyed their lives. Jury's also not supposed to make the decision based on what the outcome or the punishment would be. Is he kicking, like swinging his feet under his desk and kicking something? We're 15 seconds away from an hour and a half on the deliberation counter. No sign of questions or a verdict from the jury. In the Urick case, the most compelling evidence that was presented was his own words, his own text messages, his own Instagram messages. He literally spelled out the crime ahead of time and documented it in text form as it happened. And then for him to, plead not guilty, he has the right. Everyone has the right for the state to prove the elements. I think the state proved the elements of the crime quite well. Good morning. Who do we have here? Who am I blocking? Oh, good.
Good afternoon. I think I've got everybody I need.
Joshua
I've
Ferris.
got Joshua Ferris, Elisa Ferris, Jamie Kreitz, Meg Bauer, and John Bush, number 2.
Jamie has a sign that says 48 days to Christmas.
Mr. Ferris, can you hear me?
Why is Jamie?
Yes, sir, I can.
Mrs. Ferris, can you hear me?
Yes, sir, I can.
All right. This is a termination of tenancy case. Mr. Kreitz wants you guys to move. And he served a notice to quit on you in August on the 25th. As a defendant in such a case, a termination of tenancy case, you have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you, and we do have a legal aid attorney here with us today, Miss Meg Bauer from Western Michigan Legal Services. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first appearance or make the demand in writing within 5 days of today, filing the jury demand form, and be prepared to pay the $50 jury demand fee.
What is Alyssa doing?
Unless the judge waives the fee for your inability to pay it. You may be able to reach an agreement with the landlord by going through mediation. If both parties are agreeable to that, a court could help set it up. Or you may be able to reach an agreement that would result in the conditional order of dismissal, and we would assist in preparing that. Probably, if it was such a thing, Mr. Bush would prepare it.
Josh is having
the termination of tenancy
refreshing
was
beverage.
filed on August 25th, post the lease period. It's a month-to-month lease. He has to give you at least 30 days notice. And that would be September 5th, and then, or 25th. Then we went through October and now November. So that's correct, Mr. Bush. Plaintiff just wishes to terminate tenancy.
That's accurate, Your Honor.
Mr. and Mrs. Ferris, what's your position?
I'm wanting to demand a jury trial.
All right.
A jury trial to be evicted from your...
Ms. Ferris, what's your position?
Yeah, we would like a jury trial.
Do either have a law degree?
No.
You know anything about the rules of evidence?
Yes, sir.
Right.
You do?
You have to file the demand in writing and pay the $50 jury demand fee. Why don't you wish to move? Will you hold still, Miss Ferris? You're making me nervous. This is like watching a episode of a handheld TV camera show.
Sorry.
What's your basis for a jury trial?
All right. So back in 2024, I know that ain't got nothing to do with it now, but Larry decided that he wanted to evict us. Okay, so
who's Larry?
He told us if we came up with the remainder of the money that we owed him, that it would be dismissed. And so we came up with the money, and it got dismissed. Well, what we didn't know is that Larry told us that we were to pay for the court fees and the lawyer fees regarding the 2024 eviction. And so we paid that to him. And I was
Well, at
told
this
that,
point, he's not asking that you pay anything. He's just asking that you move, and has been asked that you move since sometime before August 25th.
Can I speak?
Yes.
We have 3 kids, and we're getting into winter months. And the housing resources, we're working with Neighborhood Inc., but the housing resources are just not there. Like, we're looking for a place. We're trying to move, but Neighborhood Inc. is in the process of helping us, but they've sent us a whole landlord resource list for private landlords, regular landlords. We filed at Village Manor. There's a year's wait list. That's the reason why we want to fight it. One is because we have children and we have nowhere to go.
Yes.
All under the ages of 12.
Well, the first thing we need to do is continue this matter for.
I wonder if they're allowed to smoke in the house because he's
Ms.
smoking.
Ferris,
right
why
now.
can't you stand still?
Because I have really, really bad anxiety.
All right, well, we'll try to do the best we can. If I do grant a jury trial, I'm going to do an escrow order. So you're going to have to pay the rent to me, and I'm going to hold on to it. You don't just get to live there free for months while this matter gets set for a jury trial. So you have to pay your rent to me, which will be less rent you would have to go to another place. And I hear this every week. People would say we would move out if we had somewhere to move to. And when you say reason for leaving last property evicted after jury trial, no one's going to want to rent to you. So it's already hard enough to find a place to move to. So the first thing we need to do is continue this matter for at least 7 days, which will take us to next week. People would move if they had somewhere to move to. But you're not a very good risk because your current landlord's evicting you for not paying the rent. They don't want you as a tenant anymore. So the next landlord may not want to take a chance on it. If you could get into one of the subsidized places, that would be good. But you're right, there's a waiting list on all of them. So you're asking for a jury trial to delay it, which it would do, but I'm not going to delay it till January, February without you paying the rent. So you'd have to pay November, December, January, and February's rent, or whenever we could set it. We have a bunch of criminal cases that also wish to have a jury trial. We haven't had a jury trial since I've been here, and maybe we had one when Judge McManus was here. So, Mr. Kreitz, what is the current rent?
I do not have that with me, Your Honor, as we weren't going after
the
rent. I would have
well,
to.
Let's look at the lease. That'll give me a clue here.
hey, Your Honor.
Yes.
And to also talk to you about the lease. Okay, Larry also bumped up our rent. I want to say it was the following last year. So the amount that says that we have to pay him on a 185, that isn't correct because we've been paying more than 185 a week, and that's because before everything was said and done, we paid Larry. I want to say it was $10,200 back in
August
before the eviction got filed. Wow. So I just wanted to let you know.
Was that with financial help?
Pardon?
No, we sold our brand new car for it. We sold our brand new 2018 Jeep Compass to pay our rent here because Larry told us if we did that we would have a place and a roof over our kids' heads. So we sold our brand new Jeep in August of this year for $12,000, and we gave him everything we had.
In August of 25?
Yes, sir.
I can see why this would be frustrating for them.
Well, then he served a notice to quit on you on August 25th.
Yes, that's correct.
And that's what we did. That's what didn't make no sense to us.
Our representative from Legal Aid is here, and you may wish to speak to her. Let's continue this to next Friday. John, are you available next Friday?
It depends what time, Your Honor.
10:15.
I should be. I have a misdemeanor pretrial in the morning, but I'll be with a few feet from you.
All right. Let's make sure that time is available. Yes, I have 9:40 and then I don't have anything till 11. So we'll continue this to 10:15. Meg Bauer from Legal Aid is here and she's willing to meet with you right now and at least get contact information so you can discuss it further. So your car was sold in August of 25, not August of 24?
Yes, sir.
Correct.
All right.
I don't know how far behind they were, but $10,000.
All right.
That's a chunk of change.
Elisa Ferris into room 1. Josh Ferris into room 1. And Legal Aid into room 1. All right, Mr. Kreitz, Mr. Bush will address this further next week. Meg, are you in the room? There we go.
Jamie, I'm going to call you in just a few moments, okay?
Okay.
All right, very good. I'll see you next week.
Thank you, Judge.
Yeah,
Thank you, Your Honor. Enjoy the weekend.
I'm sure there's a story there, and I'm sure that some of it is sad.
Yes, enjoy the rainy, cold weekend with snow.
What, you guys having bad weather
All
up
right,
there?
we have the alleged Matthew Davidson here. He has a couple of cases.
Can they please not be landlord-tenant? Somebody's lying. Imagine some receipts will have to be shown, and maybe the story, oh, this looks like landlord-tenant as well.
Well, no, like, oppressive. Yeah. There should be some right there. There's some up there in the desk. Oh, you two are at home.
Hot mic.
Good afternoon, Mr. Davidson.
Hello, Your Honor. Happy Friday.
Happy Friday
Thank you.
to you.
In fact, Your Honor, you worked so hard this week. Why don't you just take off the next couple days?
Thank you. We have had a busy day today.
You got 4.
You got a couple of matters. Our next one isn't set till 1:45, so we need to let the clock tick a couple of minutes.
We're letting it tick.
Familiar with this property.
You'd wait
Mr. Deerduff had other people living in there and there were problems with this property and
my only point was if you wanted to do them together, we could do them at 155.
well, I need to get both parties here, I guess.
Fair enough.
We'll see who shows up first.
Yeah, I don't know if you can see it, but Bruce Butchbaker's here. Representative of
Heartland. Heartland Rental Properties is the current owner. Who did you purchase this property from?
You're asking me, Bruce?
I can't hear you very well.
Hey, speak up.
Yeah, that was a while back. My son and I bought it, and then we split up our LLC.
Who did you buy it from?
All right, was this the property that had the motorhome parked in it and a bunch of other people in it?
There's been quite a number of civil or city infractions while Carrie Deerduff was in charge of buying it from my wife and I.
All right, well, let me look at this for a minute while I'm waiting.
We bought it from Crystal Heveland, if that name means anything to you. My wife and I did.
The judge knows the property on site.
Maybe my son and I. And then we ended up fixing it up and selling it to Carrie Deerduff, Mr. Carrie Deerduff.
Yeah, I had several cases with Mr. Deerduff doing evictions, but you're telling me he didn't even own the property?
He was buying it on land contract.
Okay.
And
Yes.
he paid his payment, but he got behind on other.
All right, I can't hear you very well, so let's just wait.
Insurance and taxes and.
All right, just stop. He's not here yet, so we need to wait for them.
Just stop.
All right, so yeah, he kept getting people in there and evicting them, and
he has since quit claimed his land contract interest back to Heartland. So he did have an ownership interest. He does not now.
All right.
Trying to find the Abney case. Was he the one in orange and white stripes, Josh?
That helps. This is my cousin lived at 116 West Bennett, and I spent a lot of time in that neighborhood. That was an apartment building even 50 years ago. It's got nice income potential if it was managed better. There are people looking for housing all over the place. And it was just falling into disrepair, and he had junk all over, and so it wasn't good. Here's somebody by telephone only.
We're gonna bail. We're gonna bail, Judge, because it isn't ideal. We're still keeping an eye on the court out of Texas, but we do have a sentencing that happened out of is this Ohio? I think it's Ohio. Can never remember. This was Mr. Abney, and Josh, if you were able to help us out with a little bit of the breakdown on just what happened on this one, that would be just to remind us of the case. I will show you the video. That's right here. This happened when we were busy watching other stuff, other court. And so this happened in the background. So I think that's our defendant over there in the orange and white. Let's see if I can get a little closer to the start time. There we go. Here we go. Remember his lawyer? Looks familiar. We kind of gave up on him. Judge Abney in Ohio, or Jerry Abney in Ohio, Judge Teep. What was his crimes again? This court watcher lady is super happy to be here. Abney with his girlfriend, the meth was under the seat. He said it was his, then tried to recant the statement. Lots of drugs in the car. How do they keep the carpet so clean? I think they have really good janitors. Looks like he's signing away next couple years of his life. Pound of meth or something. He has another case with the same charges coming up. Oh, nice. It's always good to have a few cases in the system. Make sure one of them sticks. You remember this attorney? Everything's been explained to him right now. This was, didn't he have the firearm inside the secret? Was there a gun inside the secret glove compartment or something? He was set for another trial for another set of charges. Was found guilty on a trial we watched and is pleading on this one for the new set. Are they doing combined sentencing on both of them? Or are they being handled separately? It's all coming back. It's coming back to me now. He had 2 firearms. Where did I go? Oh, I'm here still. Good. Y'all surprised the jury's not back yet? Yes, I'm definitely surprised we're not back yet. Let's see if we can bring up our timer. We have audio from our Texas court live. So if the audio comes in, we'll know. We're not going to miss anything. We're also keeping an eye on it right here. So you can see that we're there, but we'll be here for just the time being. If you guys see anything on the Twitter web or the internet verse or whatever it is regarding the Urick case as well, do give me a heads up. We are trying to keep our ear to the ground to make sure we catch as soon as something happens, because we would love to play some verdict music today. But as we near an hour and 50, basically all of us are going to, if it takes another 10 minutes, all of us will be wrong except for 10%. 10% of us will have been right. So maybe the jurors took an extended lunch break before starting to deliberate. They did like extended lunches, Paula Mack. That's a great point, and that counts against them on the time because they can start deliberating whenever they choose. This is the one Legally Blonde attended. X switch which I do have a wall of screens, but only 5 of them, only 5 if you don't count my phone. But one of them, the biggest one, does have 16 windows in it, if that helps. Peter Tupperware says, I had a beer inside of the secret compartment in my 2016 vet once. I got out of jail. I had a drink. Some never learn. Waiting for the judge. Might skip ahead just a teensy bit more. Since this is on tape. It only takes about 20 minutes, I think. Everything's signed. Already, I think they're getting the judge right now. I think it's about to start. Swore I voted for 1 to 2 hours. I guess the second lowest amount of time because of the lunch break in consideration. 130 MKY. Thank you very much for the boiled peanuts. I got them. It was packaged incredibly well. I'm super excited about some of the seasonings. This burning hot one. I might give this a. Ooh. Oh, it's warm. I just popped it open, and it's tickling the old schnoz. Whew. Spicy. I might have to sneeze here in just a second. I think I got a little dust. Whoa. It's not kidding. Sloth Life, you missed. Josh sent me a new goat. It's the Halloween edition, which the speaker is great quality on this one. Super impressed. Whew. You're not supposed to snort it. I know that now, but you didn't say anything before. This one is spicy. What does it have in it? The words are small, so I can't read them with my old eyes. I have to use my my Zoom on my phone. You guys know, if you know, you know. This is a couple of you have to do this as well. All right, let's see. All right, ingredients: salt, spices, garlic, onion, chili powder, chili flakes, and sugar. No, there's something else in here. There's something deadly. Because they got me. Red pepper. It's pretty warm. Here's the judge. Okay, here we go.
Please court now in session. I will just presiding. You may be seated. This is case number 25-CR42469, the State of Ohio versus Jerry Abney. Mr. Abney is before the court with his counsel, Mr. Engel, Ms. Nicholson, on behalf of the State of Ohio. Ms. Nicholson.
Your Honor, it is my understanding the defendant will be entering a guilty plea to counts 1 and the associated specifications, count 3, count 4, and count 8 under case number 25CR 42469. The state will be dismissing count 2, count 4, count 5, count 6, count 7, and all other specifications. And he will be, there will be an agreed recommended sentence on that case of 1 year in prison on the firearm specification to be served prior and consecutive to 3 to 4.5 years on count 1, a 36-month sentence on count 3, an 18-month sentence on count 4, a 12-month sentence on count 8, all to be served concurrent for a 1 plus 3 to 4.5 year sentence on that case. That will be served consecutive to the sentence in the case that we had a trial on, which
hang on.
in.
While this is going, we've got motion in court. We've got motion in court. Hold, please. We're not sure what it is yet. Hang on. Defendant is here. That means it's either a question or a verdict, and it's at 1:56 was the time. Still not seeing any updates. Under 2 hours. Could be a question. Defendant seems quite calm. I've not seen his counsel here yet. Peter Tupperware hates the verdict music. I'm sorry, Peter. You've been outvoted, unfortunately. I'll warn you before it happens. Give us a minute here to see. Of course, we go blurry for old time's sake. If the jury did take one of their extended lunches, being about an hour and 15 minutes, it's quite likely that that they had a quick verdict. There's a prosecutor. There's everybody back. There might have been a question.
The court has received a jury communication. After consulting with the attorneys, it appears that the request is merely exhibits that they're requesting. So the court is going to attach all exhibits responsive to the request, and it's in the back. Is everyone good with that? Anything for the record?
That's fine for you, Judge.
Okay, very good. Then we will send all of these back. Let's go off the record.
So 2 hours in, the jury wants more data. They want to see everything. The exhibits they have, they're going to be text messages. They're going to be Instagram records. They're going to be cell phone extractions. Basically, they're going to be looking at the words of Uriah Urick. And then move forward from there. I don't know. I'm surprised, honestly. I'm surprised that's Peter. Peter's like, haha, no music. I'm surprised that it went that way. But I would say this would be a good sign for the defense definitely. But what didn't they have already? Seriously, why would they not? We didn't hear the question. Sometimes we hear that evidence goes back, but exhibits don't in some courts, and with the juries, the counsel both agreeing to it going back, it could be just additional stuff that had not gone back before. So one cannot make bricks without clay. Yeah, I do like seeing a jury take their time. It's not an injustice to see a jury do a thorough job, especially if there's somebody who is very new to the process and doesn't understand it. I don't like the idea of a juror sort of watching whatever everyone else is doing and going along with it. That's not justice. So maybe if there is somebody who needs to do a meticulous analysis of that, it's all good. So we passed the 2-hour mark. 90% of us are wrong. Congratulations to the 10% of you who are still in the running as far as this goes. We're going to go back to our court here in Ohio and pick up where we left off with the sentencing of Mr. Abney.
To be served prior and consecutive to the mandatory 11 to 16 and a half year sentence on count 1. There will be a maximum sentence on all of the other counts to be served concurrently for a total sentence of 1 plus 11 to 16 and a half for a total aggregate sentence between both cases of 16 to 23 years.
All right. Mr. Engel, does that sound accurate?
It does, Your Honor.
Okay, Mr. Abney, they're telling me on this 42469 that you're going to change your plea to 4 of the counts from the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
41.
How far did you go in school?
11th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you other than this recommendation that's being made to me, not only in this case, but also in case number 42569?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Engel?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. This is called a change of plea. On the 3rd page of this document, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, I did.
And you believe you understand what it says?
Yes, sir.
The first count is one of aggravated trafficking in drugs, a felony of the 2nd degree. That carries First, do you understand that you're pleading guilty to one offense here that carries what's called an indefinite sentence?
Yes, sir.
So you understand that with regard to this offense, you're pleading guilty to that carries a maximum penalty of maximum minimum term of 8 years and the longest maximum term is 12 years on that offense alone. You understand that?
Yes, sir.
Then with that, there is a firearm specification of a 1-year firearm spec, which is required to be served consecutively to whatever the term of imprisonment is on the F2. Do you understand that?
Yes, sir.
And you also understand that you're going to receive, so you'll receive both a minimum term and a maximum term on that offense alone. Do you understand that?
Yes.
So the court's going to select from a number between 2 and 8 for the minimum term sentence. 2 being the minimum term, 8 being the longest minimum term.
Like
right?
a lottery?
The maximum term is automatically calculated to be whatever number the court selects as the minimum term to be that number plus half that number. So on that offense alone, the longest minimum term is 8 years, the longest maximum term is 12 years, plus the 1-year gun specification. Do you understand that?
Could it be any more confusing?
You also understand that all the other 3 offenses for which you're pleading guilty, the court will also pick a definite term of imprisonment for each of those offenses. Do you understand that?
Yes, sir.
So on the weapons under disability, that is a felony of the 3rd degree and carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. The receiving stolen property is a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. And the obstructing official business is a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Those are the maximum penalties. So do you understand that whether these sentences run concurrently with each other or consecutively with each other affects the length of both your minimum term and your maximum term of imprisonment?
Yes, sir.
All right. So I'm going to do some math here real quick.
I think this.
So the longest minimum term on these offenses is, if my math is correct, 14 and a half years. Nicholson, can you confirm that? 8, 9, 10, 11, 12, 13, 14, and 14 and a half years is the longest minimum term sentence that you could receive. The longest maximum term, no, I'm sorry, yeah. The longest maximum term sentence would be 18 and a half years. Okay, so I've just added 4 years onto that. That's what I did, okay?
Yes, sir.
And then you understand that there is a rebuttable presumption of you being released after you serve the minimum term or the presumptive early release date, whichever is earlier. Now, the Department of Corrections may rebut that presumption through an administrative hearing process and maintain your incarceration for reasonable periods of duration up to the maximum, as I've said, 18, I'm sorry, lost my math again, 14 and a half years, okay?
Yes, sir.
I'm sorry, 18 and a half years is the maximum term. The criteria for the Department of Corrections to rebut that presumption and to maintain your incarceration after you serve the minimum term with the presumptive early release date, whichever is earlier, include the following. Number 1, during incarceration, you commit a rule infraction that compromise of prison security, compromise safety of staff or inmates, cause or threaten physical harm to staff or inmates, or you commit a violation of law that was not prosecuted, or any infractions or violations which demonstrate you have not been rehabilitated and or that your behavior demonstrates you continue to pose a threat to society. Number 2, regardless of the classified security level at the time of the hearing, you had been placed in extended restrictive housing within the year preceding the hearing date, or number 3, at the time of the hearing, you are classified by the Department of Corrections as a security level 3, 4, 5, or higher. If the Department of Corrections rebuts that presumption, the Department of Corrections may maintain your incarceration in a state correctional institution under the sentence after the expiration of the minimum prison term for an additional reasonable period of incarceration to be determined by the Department of Corrections, not to exceed the maximum prison term. Also, the Department of Corrections may maintain your incarceration more than one time up to the maximum term. The Department of Corrections shall release you on the expiration of the maximum term if you've not been released prior to the expiration of that time. Since this is a mandatory sentence, you are not eligible to receive the exceptional conduct, earned reduction of minimum prison term credit. Now, on the felony of the 2nd degree, I did not mention that there's a maximum fine of $15,000. $7,500 of that fine is considered to be mandatory. So do you understand all the maximum and mandatory penalties involved with these offenses?
Yes, sir.
In addition to those, on these charges, you're also subject to a mandatory period of post-release control, which means that upon your release from prison, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. If you violate those terms of supervision, you can be returned to prison by the Adult Parole Authority for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a second trial.
Yes, sir.
This is how you want to proceed?
Yes, sir.
All right, Ms. Nicholson.
Your Honor, if this case had proceeded to trial, the state would have proven beyond a reasonable doubt that on or about February 17th of 2025 in the city of Franklin, Warren County, Ohio, the defendant was a passenger in a vehicle on a traffic stop. Upon being asked to exit the vehicle, the defendant became argumentative. He was ultimately taken out of the vehicle. A firearm was found in his waistband. Additionally, there was 31.42 grams of methamphetamine, a Schedule II substance, found in the vehicle that the defendant took ownership over. The firearm was loaded with one in the chamber. The defendant is a convicted felon and is unable to possess firearms.
Mr. Engel, anything on those facts?
No, Your Honor.
Mr. Abney, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we just went over?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty, and based upon the statement of facts and your plea, the court will make a finding of guilty. Ms. Nicholson, anything before I sentence him?
No, Your Honor. We would ask that you adopt the agreed recommended sentence. In both cases, you order forfeiture of the firearms. In the case that we had a trial on ending 560, that you order the forfeiture of the $520 in U.S. currency. On the case ending in 469, the defendant has 262 total days of jail time credit. That is allocated 231 days on the case ending 469 and 31 days on the case ending 560.
Thank you. Mr. Engel, anything?
We too would urge the court to adopt the joint recommended sentence on both cases. We'd ask the court to find Mr. Abney to be indigent for purposes of any mandatory fines and costs. We've submitted affidavits to that effect. Otherwise, I know the court's very familiar with Mr. Abney.
Mr. Abney, is there anything you want to say before I sentence you?
Just want to apologize, Your Honor, for being here today. I wasn't trying to be in any type of bad manner toward anybody when I didn't take the deal and I went to trial. I just felt like that my previous attorney didn't represent me to the best of my ability. He didn't give me all of the evidence that they had against me before I declined the deal, where I would have took the deal more seriously than what I did. And I just want to say that I'm sorry and I apologize for my mistakes.
Okay, sir. Thank you. The court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on case number 42560, well, first let me deal with the merger. The court is dealing with.
So, Your Honor, count 1 and count 2 will merge.
Right. I'm just going to go through this. The court is dealing with the multiple offenses arising out of the same conduct. The court does find that counts 1 and 2 are allied offenses of similar import and merged together, with the state electing to proceed on count 1.
That's correct.
And counts 4 and 5, again, are allied offenses of similar import, and those merged together, the state electing to proceed on count 5.
That's correct.
All right. So on count 1, the court is going to order you to serve a minimum term sentence of 11 years. There is a gun specification on that is 1 year that must be served consecutive and prior to the minimum term sentence of 11 years, which makes your maximum term sentence 16 and a half years.
Could you get out sooner on good behavior for parole?
There is count 3 is the weapon under disability. The court's going to order you to serve 36 months in prison. That to be served concurrent with count 1. I'm sorry, I'm looking at the wrong thing. And count 5, the improper handling of the firearm, the court's going to order you to serve 18 months in prison. Again, that to be served concurrent with count 1. The court does find that you have, on this case, 31 days jail time credit. The court orders the gun forfeiture. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions, including the mandatory fine.
So it doesn't have to
Under
pay the
case number
$7,500.
42469 on count 1, the court's going to order you to serve a minimum term sentence of 3 years, maximum term sentence on that count of 4.5 years. There is a 1 year gun specification, that to be served prior to and consecutive to count 1. On count 3, the court's going to order you to serve 36 months in prison, that to be served concurrent with count 1. On count 4, 18 months in prison, again concurrent with count 1. And on count 8, 12 months in prison to be served concurrent with count 1. Count 1 to 3 to 4.5 years plus the 1 year gun spec is be ordered to be served consecutive to the sentence of 42560. The court does find that consecutive sentences are necessary to punish this defendant. It is not disproportionate to the conduct or danger posed by the defendant, and the two or more offenses are part of a course of conduct, and the harm caused was so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct. The court will also find that you have 231 days jail time credit on this offense. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions, including the mandatory fine. Now, you are also, on both cases, subject to a mandatory period of post-release control, which we went over a minute ago. Do you want me to go over that with you again?
No, sir.
All right. Since these are mandatory prison sentences, you're not eligible for the earned early release. You do have a right to appeal the court's decision of your sentence and the jury's verdict of your conviction on the prior case to the 12th District Court of Appeals. Now that you have been sentenced on that case,
no early release.
You must file your notice of appeal on either case or both cases within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including hiring an attorney, all of that can be provided to you at no cost.
Are you ordering the forfeiture of the firearms?
Yes, I'm sorry. On case number 42469, the firearm is forfeited and the money was forfeited, as I indicated. Okay. Anything else, Ms. Nicholson?
Do you only want the consecutive? So you're running 42469 consecutive to 560. Do you want the consecutive? Like, do you want them each to run consecutive to each other, or do you just want the consecutive findings in the one entry? It may be a
no. I think you probably ought to cross-reference them so that there's no confusion.
Yes.
That the 42560, which I sentenced him on first, the other one is consecutive to that one. But you might want to reference it in both sentencing entries.
I just want to make clear for the record, the findings are going to be in both entries.
Yes, yes.
We understand they're running consecutive.
Broken Baker,
Yes,
I want to
thank
address
you.
this in just a minute.
Mr. Ingles, or anything else?
Two things. I'll just state on the record, I believe it's the court's intention that the aggregate sentence on both cases would be 16 to 23 years.
That's what I have, correct. Minimum term sentence of 16, which is the 3 plus 1 on the new case.
That's the gun plus the other.
And then 11
Plus 1.
plus 1 on the old case.
Okay.
So
Case
12
we
plus
already
4
have.
is 16.
And then Mr. Abney has asked me to file a notice of appeal on his behalf.
Oh, nice.
560 case, which is the one that went to trial. We'd
He's
ask
already
the court
appealing.
to find that he is indigent and appoint counsel for him.
Once you have them, I just found it, I have these affidavits. Okay, we'll do that. Why don't you file the notice of appeal, and then we'll appoint new appellate counsel.
Great, thank you.
All right, great.
Lawyer wants off. I'm not doing it. All right, let me.
Is there anything else?
I don't think
We're
so,
just
Judge.
confirming jail time credit. No, Your Honor.
Okay. I need you to sign this.
Oh, yes. I approach.
All right, so that wraps up that case. We watched this one previously. We had to jump back and get that. As we wait for this, Broken Baker, let me address your comment particularly. Why is this taking so long? It seems like a pretty cut and dry case. I think you were saying something along those lines. There it is. Not only is it cut and dry, but the defense lawyer in his closing statement, which is the only time he got up and spoke to the jury, he did not give an open, told the jury his client did it and that he was not asking them to find them not guilty. That is, first of all, it's bizarre. I mean, even if you believe that, I don't think you have to say it. You don't have to argue the state's position for them in the defense. Just as narrow and slim and as poor an argument as it may be, stick to your defense argument. Don't reinforce the state's. That's just like lawyering 101, right? Yeah, I have no idea. Maybe let's give the jury some credit here. Maybe they took a 2-hour lunch. And they just think that, aren't we supposed to get the evidence? And they just like the appearances of it being right. They've had everything delivered to them maybe 20 minutes. They took a 2-hour lunch. That's what I'm thinking. Took a 2-hour lunch, and now they've just got a foreman. So reset the timer. Maybe that's what's happening. Find him guilty, just not capital, is what he had said. Capital being the minimum mandatory is life without parole. And the maximum is death penalty. But I haven't heard they're going for death penalty on this at all. It's possible that it's there. They just haven't talked about it. But we know for a fact that with Tara, her being 17 when this went down, the Supreme Court has ruled it's not constitutional to hang the death penalty over somebody's head if they're juvenile, and she would be juvenile when this happened. So we know for a fact the death penalty is not even on the option for her. So maybe they want to talk about it for a little bit, possibly. Hey, there's another judge I saw just active just a few minutes ago, and I wanted to grab this before it disappears. And it seems like it ended somewhat spicy. This is Burnett Court. Let's see if we can jump in there really quickly.
And I wish it could be nicer because it was going to be a plea.
It was supposed to be.
It's just a few minutes long, less than 10 minutes. Give us a second here. I don't know. This could be like divorce. This could be civil. I have no idea. Well, there's a plea.
We will go on the record in the matters 24 CT 102, 24 CF 245, State of Wisconsin versus Jason Belisle. The state appears through District Attorney Kevin Schmidt in person. We have Nicholas Davis, Defense Counsel, in person. Mr. Belisle fails to appear today.
Ooh.
We're set for a plea and sentencing. We were scheduled for 1. It is now 1:06. The court will note that I do have my cameras up throughout the building, and I do not see
She's spying on the whole
him
building.
nor anyone actually in any area to be coming in or close to the courtroom.
The courthouse is a ghost town.
Maybe a bit chilly outside, but the weather is good driving condition. He fails to appear. What is the state requesting?
DOC had alerted me on Wednesday that he was in absconder status and has a warrant for his arrest from DOC. So I think that's probably related. I'd ask for a warrant.
All right. Mr. Davis, stand mute or
I
make
do.
an argument?
With your permission, I'd like to stand mute because I don't have any information.
All right, so the court is going to issue a warrant. $1,200 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon the posting. The court will forfeit the cash previously posted pursuant to 969.13 of the Wisconsin statutes. Mr. Belial has already had $250 forfeited in this case for a different failure to appear. He is currently or was currently on $750 cash.
He's lost
and that was
$1,000
not
bucks.
enough to assure his appearance for today. Therefore, the $1,200 is appropriate. We are adjourned.
Thank you.
Ms. Barber?
$1,000 he's out. He doesn't show up for his plea and sentencing date. Let's see what happens on this one. This judge, I like this judge, especially for her.
You don't have to be nervous.
Her drug court.
You're good.
I think she does a
It's all
great
fine.
job as a drug court judge. She can get a little abrasive in some of her.
We
other
will go
cases.
on the record in the matter 25 CM 213, State of Wisconsin versus Rose Barber. The state appears through District Attorney Kevin Schmidt in person. We have Defense Counsel Nicholas Davis in person. Ms. Barber appears in person as well. We're set today in this matter for an initial appearance. However, before I proceed down that road, Mr. Schmidt, is this one case where an offer could be presented prior to going down that track?
My offer in this case would have been plea to obstructions and ordinance for 330-50.
So do you understand what that means, Ms. Barber?
No.
It would be, the state is asking the court, can you please amend this from a crime to a ticket? All right, like an ordinance violation. It's kind of like a traffic ticket for $330.50. Sorry. You want to talk with your attorney about that?
I could do that.
Your Honor, if I could, I'd have just like a, if I could just, again, I'm assuming you'd allow this to be done with a stip in order. She agreed, I would just like a chance to talk to her, just to sit down and explain it to her. I mean, you have, but I would feel more comfortable. I mean, and I'm talking as soon as next week, we could probably have a stip in order for you to sign.
Yeah, I sure will. If you want to make sure that you can talk to your client, I mean, she is a paying client, I believe.
And Rose always takes my phone calls, so it'll be easy.
I mean, you could, I don't know how much you have to go through. You can do it today, or you can do it on the phone or make another appointment. I don't care. But that's the offer, Ms. Barber. It's going to remain on the table. What your attorney is asking of the court is that I set it for another date and time, just so he can talk to you to make sure that you fully feel comfortable about everything that's going on and that he covers his mind. Because
Assets.
he is paid to represent you vigorously. All right. And so what could happen is I'll set this for another date and time in the future. And if you agree after talking with Mr. Davis that that's what you would like to do, they can do it by paper. You won't have to come back. Okay.
Oh, okay.
Okay.
Yes.
So you won't have to make that trip.
Oh, okay. That's a relief. Oh my God.
Whatever date you pick, I'll say yes, because I think it'll be finished before then, that date.
Well, I'll just throw out December 15th at 10. I know you're coming back that date and time. And again, you can listen to that date and time. You don't have to, because let's just say something blows it out of the water and Mr. Davis says, oh, it wasn't even you who was at this incident, not having you say anything to the court. And then he's like, we have to go to trial. Then he will call and he'll remind you and say, hey, remember we have court. Okay?
Okay.
And a notice. You can come and get your notice too, though, but don't feel like you have to come back unless he tells you you have to come back.
Okay.
Okay?
Call you next week, okay, Rose?
Okay.
Yeah, that
We'll
wasn't
grab
very
your notice and
spicy.
you can go home.
I watched
Okay.
it without any audio. I saw her doing this.
That's
like
okay.
this. I thought she was getting
All right.
spicy.
Thank you.
Yes, thank you.
Thanks, Judge. Appreciate you. I think I think she's done. She's still alive. She might still be alive. Let's check. Oh, she's back. I think she came back. Let's see what happens here at the end. Maybe it's just her signing off. Approaching 2.5 hours deliberation time total for the Texas jury in the Urick trial. Counted in the corners for that jury deliberation. I'll tell you, for those who joined us from Broken Baker's channel, we did a poll on deliberation time, and 90% of us felt that it was going to happen within 2 hours. So only 10% still in the running for nailing the deliberation time on this one. So obviously we saw something the jury didn't, or maybe the jury saw something we didn't, because we were wrong. Looks like she's not coming back. Okay. She gone. We'll keep an eye peeled for any of our other favorites who may be holding court today. A lot of courts hold Fridays separate for landlord-tenant deals, which are not the most fun things to watch. Honestly, it's basically a very sad day for somebody who's in a very bad way. So typically we don't like to follow those very much unless there's a compelling factor at play. But let's see what else we have here. Let's see. Burnett Judge, her stream's still live, but I'm just not seeing anything. Judge Wolf, Judge Simpson, is he doing landlord-tenant? He is. Let me take a peek and see what it's got going on. Nope, not him.
With them, normally I would do this in this case, but you've done that. So don't bring. I'm going to do that, but still bring those funds here, and then I'll pay it out. So I'm just going to indicate defendant.
Sounds like an escrow situation.
Pay
landlord-tenant.
You don't put a escrow, and court will release. So that way we're not going to have where you're trying to pay on this judgment and that whole issue there. Still pay it here, and then we'll get it out to them.
Okay.
Okay, but I'm going to give you to the end of the month, try to get this clear.
Thanks, Judge.
The full amount.
Yeah.
Okay.
All right, but if you're working with them and get the balance down, I think they'll work with you.
Yeah.
Okay?
Thank you.
Thank you,
welcome.
Your Honor. You have
Thank
a great
you.
weekend. I believe that's call my court.
That is it. Take care.
All right, I'm going to bail because he is doing more landlord-tenant stuff. I do want to say that this case we have right here in Urick, with Urick, is interesting to me. First of all, it's a very sad set of facts where he is charged with shooting and killing the grandmother of his girlfriend, whose home he was living in without the grandmother's knowledge. He was hiding under a table, peeing in bottles because he couldn't get to the bathroom, living in his girlfriend's bedroom under a table, which is just bizarre in and of itself. But in this case, he's charged with shooting and killing his girlfriend's grandmother. Right now, right this very minute, we're in day 10 here in North Carolina, eastern North Carolina, of a manhunt that involves the Marshal Service and a whole bunch of law enforcement for a man who is charged with killing his grandmother just here a couple counties away from me, and burning the house down to the ground. Then, when he went on the run, he was approached by a law enforcement officer at a restaurant, a fast food restaurant, I think. He stabbed the officer and went on the run again. He's still loose, and right now the manhunt is continuing. Day 10 of that one, and they have found him on trail cameras in a number of areas, and they're able to sort of track where he's at. He's literally walking my direction. So he could be in my town right now, and I expect possibly even by as close as much as this weekend we'll start seeing some search helicopters and things flying over our area, because we are in a pretty rural area, and so that's happening. So possibly another case to watch coming up. The officer was not fatally wounded. I think he was injured, but not severely. So he's coming for the candy bowl. That's what we're afraid of. So anyway, lots going on in the world of true crime. I just don't like it when it strikes quite so close to home. All right, looking live back at Warren County. Nothing going on in their courtroom right now. That's an interesting court because they literally live stream 24/7. They only stop if the power goes out. Let's see. Up in Thurston, might have a little something going on in Thurston. Let's see what's happening here.
You're on. Are you able to hear us okay?
Yeah.
All right, so we're here for trial confirmation.
Your Honor, the intention is to enter a disposition in Mr. De Jesus Lopez's matter.
I just confirmed that's been signed by a prosecutor.
I informed Mr. Weston that in Canada, the court had not pulled up the document in Laserfish.
They use Laserfish for their court documents. They all have access, and they can pass them around a lot quicker than emailing them.
Notes about signing, so I just want to.
Royal Oak Traffic. Oh, if it's live, we'd love to go there. That's always a fun one to pop in on.
And the internet is actually not allowing me to access, or my computer is not allowing me to access Laserfish this morning, unfortunately.
Mine just froze. So.
Josh says there's a wild eviction case happening.
Is the SOC document in the states folder still? Oh, I'm sorry, you can't access that.
No, that's okay. Nothing in the pre-negotiations folder. I don't see it in the judges folder.
Just a JNS in the judges folder.
Possible it got put in the wrong time.
One moment here.
Tumwater, Troy. We're in your neck of the woods right now, Thurston County. Always a good time when we visit up here.
That's a 10:30.
I thought he was wearing. He does look like he's at a fast food restaurant. That's like the walls give the fast food restaurant vibe.
Are there any other cases ready? Well, those are.
Yes, I can.
Not to make you multitask too much.
Oh, that's all right, Your Honor. I can call Elijah Saucedo's matter. Mr. Saucedo is present online.
And that signed SOC should be in the judges.
Bass Pro Shops represent.
Morning, Mr. Saucedo.
Everyone's wearing hats today.
Good morning.
Thurston County's pretty laid back.
SOC, is that right?
They're just happy you show up for court.
Yes, Your Honor. The intention is to enter a disposition. There are two SOCs in with Mr. Saucedo's name, and Your Honor, that is related to the fact that there are two cause numbers arising from the same factual occurrence, and the terms of both SOC documents should be identical.
Did he just pass fries past the phone? Is he working the drive-thru while he's in court? I swear I saw a large fry. I think Lopez is working the drive-thru right now.
Mr. Saucedo, I have in front of me, two documents. They're both titled stipulated order of continuance. I'll go through the first one with you, and then
maybe Saucedo is in the drive-thru.
The second one, maybe in a bit of more expedited manner.
This would be epic.
So a stipulated order of continuance. This is an agreement between yourself and your attorney and the prosecutor on resolving the case pre-trial. And do you feel you have enough time to go over this document with your lawyer?
Yes, Your Honor.
Looks like for the matter ending in 4433, you're currently charged with reckless driving and driving with a suspended license in the second degree. Those are both gross misdemeanors. And the agreement here that this matter will be continued for a period of 18 months. A new commencement date then of May 7th.
Put the fries in the bag.
Conditions would be to not consume any alcohol or non-prescribed drugs, not to commit a new law violation, and not to drive without a valid license or insurance. An additional requirement is no speeding infractions with a speed higher than 5 miles per hour over the limit.
You can only speed 5 miles per hour.
Speeding infractions of 5 miles per hour over or less will not represent a violation.
That's literally, you're saying you can go 5 over.
Those conditions are satisfied.
He is in a
both
car
counts
right
will
now.
be dismissed. Do I have that right?
Not wearing a seatbelt either.
That is defense's understanding that all three charges would be dismissed at the end of the SOC term.
Correct, yes. 24-month SOC to dismissal on all three.
And I apologize, it should be 18 months since that was negotiated.
Oh, got it. Peter's notes were just outdated, but yes, whatever is in the sign SOC.
Okay, it's 18.
I want to see some
All right.
more.
And so, sir, is that
need to
your
see Happy
understanding
Meal.
too, Mr. Saucedo, of the agreement?
Yes, Your Honor.
So by entering the agreement, you are giving up certain rights, waiving your right to trial by jury, and within the speedy trial amount of time. You're also agreeing that if the prosecution brings sufficient evidence that the terms have been violated, you're agreeing to what's called a stipulated bench trial, which is where you're agreeing that the documents that the prosecution provides to your attorney can be used and are admissible and are what the judge will consider in whether or not you're guilty of the crimes charged, and that if you're found guilty, then you can be sentenced up to the maximum. Do you understand all of that?
Yes, Your Honor.
All right.
Mr. Lopez is working
The prosecution has to only prove a violation by preponderance of the evidence, so they're not necessarily having to prove this beyond a reasonable doubt.
Skybell, welcome.
So do you
Thank you very
understand
much.
that?
Yeah.
All right, so I find that Mr. Saucedo enters the SOC freely, knowing and voluntarily stipulating to the terms and waiving his applicable rights. So I will sign.
If Mr. Saucedo gets handed his drive-through order while on court from Mr. Lopez, free memberships to everybody. We'll just make it rain in memberships. Just need those two to join up right now for an epic moment in court. It could happen. It could happen right here. You can tell he's at the drive-thru. He's looking at the car ahead of him. Why is this taking so long? Just want my burger. Bass Pro Shops, not a sponsor.
You have to then reflect the terms of this.
Mr. Saucedo's back hurts. He's really sore from carrying all his friends on Call of Duty last night. It's a tough job, you know. Still no action out of Texas. I'm keeping an eye on it. Ouch, while I break things on my desk. That was my YouTube button. This is the only YouTube button they've ever sent me, by the way. And it's acrylic. I guess I have to have a few more subscribers before they'll send me a play button. But this was from YouTube. So I did get a YouTube play button. It's just didn't come with my name or anything. This was for doing a survey, survey for them. All right. It's a Temu play button, yes, but it came from YouTube. Like, I had to sit on the phone and do a. We were actually testing some of the features that they now have implemented in the Creator channel as far as the AI. I was in the test group for that. Both the function and the naming of it. I was involved in both parts of that. Never see you, Groovy Cheryl. It's because you have short sentences. You need longer sentences. And then it shows up.
Hello.
Can you play the Bring the Jury song? I can't play everybody's songs, unfortunately. There are some problems with that. I have to be very selective. I hope you understand. I do get sent a lot of songs. I just can't play them.
Council has that information. I apologize. I submitted the SOC before doing the JNS. The conditions are no criminal law violation. And then can you remind me of the others?
License, drive with valid license and insurance. No alcohol or non-prescribed drugs or medication. and then no speeding tickets greater than 5 miles per hour.
Lopez is updating us.
No,
No new law violations. I don't think
so no new law violations, no driving without a valid license and insurance, not to consume alcohol, marijuana, or non-prescribed drugs. No
We're back.
over 5 miles an hour.
Ding, fries are done. Oh, he's gone. He's gone. Bummer.
All right, sir. Thank you for your patience. So next, we've got a stipulated order of continuance for the matter ending in 4434. This is a charge of possession of cannabis. 21 years old. It's a simple misdemeanor, punishable by up to 90 days in jail and a $1,000 fine. This appears to also be an 18-month SOC.
We're seeing a little motion
Date of May
of
7th,
Urick's.
2007. Conditions here: not to consume any alcohol, marijuana, or non-prescribed drugs, commit a new law violation, or drive without a valid license and insurance. And, oh, I'm sorry, it is the same. Okay, so no speeding infractions with a speed higher than 5 miles per hour. Okay.
Are you driving right
I
now,
apologize
sir?
for any confusion there.
No insurance?
The terms, as I believe your counsel indicated earlier, are the same for both matters. So do you understand that, sir?
Yes, sir.
The prosecution showed up. They're back, but we haven't heard anything yet. This is out of Texas. Just wanted to show you what's happening. Just keeping you up to date. 2 hours, 45 minutes, 46 minutes now in deliberations. Our other guy working at Wendy's did hang up from the Zoom call. I think he had forgotten to hang up and went back to work.
That one as well. All right, and you can get copies of these from your lawyer. You can also go on the Thurston County District Court website, type in the cause number, and get copies of these documents. Again, there's the SOC, which you've reviewed with your attorney. There's also the judgment sentence form, which largely mirrors the terms of that. That document is just for. Do you have any questions?
No, sir. Thank you.
Okay, thank you. Good luck.
Yep.
All right. Always fun stopping in at Thurston here. Let's just pop into Texas for just a minute, because we're seeing a lot of people walking around in the courtroom. Just wonder if maybe they've been asked to come back or if they're just stretching their legs. Give them a minute. I'm not seeing anything. Maybe we'll jump down to Mr. Wiggins. Court hopping's fun. Hopefully you don't get whiplash. We don't stay anywhere too long as we wait and watch and listen for the jury to come back. Not seeing anything here. Waiting for a defendant, possibly. Looks like the jail has zoomed in, but no one is seated there. Lawyers are present. There we go.
Person at the Wexford County Jail, please state your name.
Mark Jones.
This is case number 254659FY. The people of the state of Michigan versus Mark Anthony Jones. Mr. Jones, you met with somebody from Community Corrections and gave them some contact information today. Is that information accurate?
Yes.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes.
Very crisp answers there. Yes.
I have a complaint that alleges that on or about November 29th, 2024, in the city of Manton of Wexford County, It is alleged in count number 1 that you committed the offense of embezzlement, agent or trustee of $1,000 or more, but less than $20,000. That is a felony punishable by up to 5 years in prison and or a fine of $10,000 or 3 times the amount of the value taken, whichever is greater.
Cha-ching.
Additionally, the prosecution has charged you as a habitual second offender, which means you have at least one prior either attempted or completed felony in your past. That makes that 5-year felony a 7.5-year felony. Do you understand those charges and the potential penalties?
Yes, I do.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, sir, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of an attorney.
And what is your current source of income?
I embezzle money.
Currently not employed right now.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Lawrence, I have a question for you. I know that this is just a single date, but the probable cause affidavit lists multiple dates. I'm just wondering if there's
probably embezzlement over time,
to
not just one.
Amend for date range, or if you're going to be moving forward on just the 1 date. All right. So we'll anticipate an amended complaint when that comes up. Historically, counsel in the defendant's past, I show in 16 an attempted larceny in the building and embezzlement 200 to 1,000. In 20, there was operating while visibly impaired. In 02, a furnished alcohol to a minor, and 08, open intox. The defendant, Mr. Harrison, am I correct, currently has charges for a financial transaction device pending. Is that accurate?
I believe it's something of that nature. He is represented by Mrs. Kursatawa on that as an overflow attorney.
Okay.
He was arraigned this morning on a circuit court potential probation violation or bond violation. So that case is still affecting the situation.
The Praxis scores him at a risk level 5, but I think 1 point is misscored because it assigns 1 point for being on bond at the time the offense happened. It looks like he was placed on bond after the event date, so I believe that
That's inaccurate. I was surprised to see that he was a 4, to be honest, Your Honor.
So yeah, I do believe he should be risk level 4. Any comment regarding bond, Mr. Harrison?
I'm well aware of Mr. Jones. I know who he is. I've known him for a number of years. He has ample family in the area to support him, and I guess what would have to be characterized as a difficult time, both in Manton and here in Cadillac. I don't view him as a flight risk. I don't view him as a threat to society in any way, shape, or form. He's currently unemployed. As long as I've known him, he's been employed. Unfortunately, one of the incidents, the allegations arose in the context of his employer at the time. This may very well be the same situation. So that accounts for his being out of work at this juncture. That's not the usual way he conducts himself. I think he's a good risk for PR bond. I don't see any history I could be disposed of that, obviously, of failing to appear here in court. Thank you.
Is he remanded in the circuit court then?
Did you enter a plea upstairs this morning, Mark?
Yes, I did.
Okay. Are you currently awaiting sentence on that charge?
I'm at $1,000 cash bond. And they're going to do sentencing coinciding with this.
Okay, all right. So it does appear that his bond was revoked in that matter. That's not true.
Additional $1,000 bond must be posted.
An additional $1,000, was he on a PR bond before? All right. Any comment regarding bond, Ms. Lawrence?
Yes, thank you. The defendant in this case stole just over $9 grand from the 308 bar in Manton. This occurred over several months of him being employed there. I did have a chance to watch a little bit of his arraignment this morning up in circuit court, and I believe that was for a failure to appear in circuit court.
$9 grand over.
Given that, I do think there is a little bit of a flight risk here. I believe Mr. Carnes asked for the bond to be set higher to reflect the amount of restitution owed in that case. I'm going to do the same in this case. I would ask for a $10,000 cash bond. Thank you.
He's like, but I've only got $9 grand.
Did he plead to the underlying offense today?
I can't afford a 10 grand.
I believe he pled as charged and the habitual was dropped. That's my understanding.
Can
Well,
you
what
use
I'm going to
your
do
stolen funds
is
to pay your
I'm
bail?
going to set a minimal cash or surety bond of $100. That way the defendant receives credit on this case if he's not able to post the additional $1,000 with the following conditions. Mr. Jones, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with the 308 bar. And no contact means no contact of any kind, not by phone, going in there, being on the property, anything like that. All right. Thank you, Mr. Jones. Next arraignment.
While they do their next arraignment, we'll peek back in here. We're approaching the 3-hour mark for the jury deliberation. Right about 2 hours in, the jury did write a note to the judge, and they asked for all the exhibits. They want everything that's exhibity in the courtroom to be sent in. Oh, we've got a prank call. Hang on. Hello?
Hello?
Hello? Hello?
Good afternoon. My name is Olivia. I'm reaching out because Medicare just launched an inflation relief package for Utah, which offers extra cash for groceries, gas, and prescriptions. It's part of the annual enrollment for 2026. So you do have Medicare Parts A and B, right?
Show me the money. Oh, they didn't like that. Yeah, that scams to get to steal your information. Basically, if you get that call and it sounds like, hey, great, free money. No, what they do is they actually put you in touch with somebody who actually does this, like a professional who would help you with your Medicare if you needed it. But they listen in the middle, and you give them all your personal information, and they steal it. So don't do that. It's just a public service announcement for you. All right, next arraignment, going back to the same court. Let's see, just waiting for the next defendant. I was too enthusiastic. I don't like saying yes to them. It's like a personal thing of mine. I don't like telling a scammer yes, because they can just like say that I agreed to something else, because there are ways they can charge you on like your phone bill for weird things. So I like to think of alternative ways to agree to something. Skybell says, well, Scott, 27 months. We call you Papa. You're great. Skybell, thank you very much. 27 months makes you an OG. Original goats. And speaking of goats, we have a new one today. It doesn't like to make a sound. There you go. They can also AI your voice the more you speak to them. Yes, but I'm already at risk for that one, Laura, because you can already get hundreds and hundreds, if not thousands, of hours of my voice on the internet for free. So basically, I've written that one off. Hey, ma'am, welcome. How are you doing?
Person at the Wexford County Jail, please state your name.
Catherine Shattuck.
She's got a Chucky shirt on.
This is case number 254712 SD, the people of the state of Michigan versus Catherine Elizabeth Shattuck.
This could be
corrections. I have a question for you. I've been told that Ms. Shattuck has posted bond, but she's being held until she can blow zeros. Is that correct?
That is correct, Your Honor.
Do you know what she's currently blowing?
That's an interesting question.
Not at this time. I can have her do one and let you know if that's what you'd like, sir.
Yeah, I would, because I want to make sure that it's proper we do an arraignment. So if you could test her real quick, I'd appreciate it.
Yes, Your Honor.
Ma'am, take a deep breath. You can put this straw in your mouth. Blow right here. Keep the green light lit. Blow, 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 blow. There we go. That was good. Well, they do it right then. Like right then. I think I heard that. Now we can't go anywhere. We need to see what she blew. She blowed. Blowed. What's the past tense of red pen? Help us out. Do we say she blew and then there's the number, or blown? Blew? It's blue. What she blew. Y'all, I just sat on a wet chair cushion. Well, if that is a sensation you won't forget, nothing transfers liquid quicker than sitting on a wet sponge. I tell you that. So it's amazing. We're invested now. We live here. Hold, please. Blown is past participle, used with a helping verb. Can you give us an example of that? I was blown away, like that? Can you dangle your past participle? Red Pen teaches English language here in chat. If any of you are struggling with the language, she's the one to talk to. She never makes a mistake. And if she does, don't mention it because it was on purpose. Has blown. Her cover was blown. All right, ma'am. Look a little lightheaded. Let's hear what the results were.
Your Honor?
Yes.
She's 0.017.
That's almost clean, Judge.
Okay.
So less than an hour at this point.
All right.
That just means she's got a hangover right now. I don't think that's...
All right, Ms. Shattuck, I have, did you have the opportunity to meet with somebody from the defender's office today?
Yes.
Also, I have, it looks like you met with somebody from Community Corrections and gave them some contact information. Is that information accurate?
Yes, sir.
Past the 3-hour mark on deliberation.
I have a complaint that alleges that on or about November 7th, 2025 in Herring Township, it is alleged that you committed, of Wexford County, it is alleged that you committed the offense in count number 1 of operating with a high bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service, rehabilitative programs, vehicle mobilization with a prior, and reimbursements for the government for costs of prosecution. In count number 2, it is alleged you committed the offense of operating while intoxicated by an alcoholic liquor. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilizations mandatory with the prior, and reimbursements for the costs of governmental expenses and prosecution. Do you understand those charges and the potential penalties?
Yes, sir.
Expensive penalties.
Did you read and sign an advice of rights form there at the jail? It talked about your rights to an attorney and your rights to a trial.
I believe so. I think so. I'm not quite sure.
You don't specifically remember doing that?
That would be the drunk part.
I know I signed a paper this morning.
All right, well, I'm going to go through it with you just to make sure that you're aware of your rights.
Know what you signed.
If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You have been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court, to have a trial by jury, and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and if the offense charged requires a minimum jail sentence, or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court. To see, hear, and question all witnesses against you at trial. To be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up those rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to make a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for the lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from purchasing or possessing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights as I've read them to you?
Yes, sir.
You already
You do have the right to have an attorney appointed to represent you. You also have the right to hire your own attorney or act as your own attorney. So my question to you right now is, do you wish to hire an attorney, represent yourself, or request the appointment of an attorney?
I would like to request the appoint one.
What is your current source of income?
Currently unemployed right now.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, it's my understanding that an interim bond was set at $250, and that has been posted. As I said before, they're just waiting for her to blow zeros before she's released.
That's why they
any
had
comment regarding bond, Mr.
And she's at 0.012.
I would encourage the court to recognize the sufficiency of the interim bond that has already been posted and allow her to be released PR once she is, or pursuant to the cash bond rather, once she has cleared zeros.
Thank you, Ms. Lawrence.
Thank you. Unfortunately, I do not have a police report yet in this case. I do know that this stemmed from a be on the lookout for a suspected intoxicated driver. The defendant did do a PBT, which came back at a 0.223, which is rather high. Given that, I do not oppose the 250 bond staying the way that it is. I would just ask for an alcohol testing.
So is there a blood draw on this one then?
I believe so.
0.22
Council, I should have mentioned, historically in 22, there was a disorderly drunk, 21, a 4A case, and 17, an operating while intoxicated, and the praxis scores her at a risk level 2. Ms. Shattuck, I'm going to continue the $250 bond as previously posted with the following conditions: that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, because this is a second drunk driving case, I couple that with a disorderly drunk and the fact that you were a .223, at least according to the preliminary breath test. I find that you are a threat to the community. I'm going to order that you not consume any alcohol. You'll be subject to daily testing. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and be subject to random testings for that. I don't want you switching one substance for another.
Yeah, she needs to get some help.
Once you are released from the jail, you'll need to come over here to community corrections at the courthouse and get signed up for your testing.
All right.
All right, thank you.
Cauliflower, thank you
Thank you,
very
sir.
much for sharing this. Congratulations. Let me see if I can play a sound. There we go. 4-year sobriety date. Congratulations, Cauliflower. Thank you, thank you. We celebrate everybody on their path to sobriety, whether it's one day or
Our next call is the people of the
10
state of
years.
Michigan versus
Or more.
Fabian Roque Cruz.
Still nothing happening out of Texas right now. We have seen the prosecution, specifically the male prosecutor, walk around in court a number of times, but no action since a little over an hour and 10 minutes ago when the jury asked for all the exhibits to be brought to them. Those exhibits include everything from the Celebrite extractions from the cell phones, all the text messages, the Instagram messages back and forth. They've got a lot of material, pages and pages and pages, volumes, I might even say, of stuff to read. Most of it is the defendant's own words, and it's spicy. There's stuff in there that I know it's a good thing they didn't read in court, because we would have had to edit that out of our live stream, because there's some pretty unclean language in there. Julianne, 950 days today clean. That is awesome as well. Quiet Papa Dan, 16 years sober. Congratulations. Congratulations, Papa Dan. That is awesome. Love that we can celebrate each other's sobriety on here. That is awesome. Good community for that. It's getting close time for me to call so we can get a verdict. Don't call the court, whatever you do. Red Pen sober for 45 years. We're counting it. Red Pen, we're counting it. That is great. You also got to... What is taking so long? Wildcats, I don't know. Unless the jury is really concerned about what will happen to the defendant because of their verdict, which they shouldn't make a decision based on that. They should make a decision based on the law that was read to them, saying, here are the elements of the crime, and then compare that to the evidence that was presented in court, whether they believe the evidence or not, and whether the state met the burden. And that should be the entirety of their deliberation. And maybe that's what they're doing. They're just being really meticulous about it. They asked for the stuff, the legal things, the exhibits. They went full exhibity on us. Let's jump back to...
Offense if you are indigent, which means without money to hire an attorney, and if the offense charged requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. To call witnesses to speak for you at trial, you may get an order signed by the court to require witnesses to come to court. To see, hear, and question all witnesses against you at trial. To be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead no contest or guilty and your plea is accepted, you will not have a trial of any kind, and you'll be giving up those rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs, and the court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent.
There we go. So hold please for a second. We're going to see if we can find another court that does a little less reading. I'd like to hear the charges, but not that. Let's see. Landlord tenants going on with Middleton still. He's a fun one to watch all the time. Let's see, we have accusations calendar. That's Fulton County. That one's not fun. Generally not spicy. Simpson's still doing landlord tenant. Sorry, I'm scrolling through a whole bunch of courts and not seeing much to choose from. Wildcats 27, thank you very much for the support. 2 months, and you got a new color courthouse. Enjoy your channel for the big cases and smaller cases. It's interesting what we learn. We love it. I learn something every day, mostly from you guys, and thank you for that. We're courtroom surfing, inside, outside, U.S. That's a Beach Boys song. I recognize that. See, my musical knowledge goes way back. He jumped to court right as my phone got a text, so it was cool. A little magical spell sound as he turned it off. Let's see. What I sent you is in mod is spicy, but not live or today. Oh, that's... Josh, I forgot you sent me that one. I apologize. Let's jump back to Kirsten Simmons. Let's see if we can get here. Judge Kirsten Simmons. Make sure we get the right one. This was 54 minutes. Is it the whole thing? I think it's the whole thing. Let's see what's happening here. This happened yesterday. Courtesy of Josh. If it's not to your liking, he's the one to blame. Crowded courtroom here. As you can see, there's a few people there. Pan down a little more, a little more, a little more. I guess I get to block everyone out.
What happened with Venture Flats versus Michelak and Smith?
I believe this is
Good afternoon, Your Honor. Jen Wilburn, P83143 for plaintiff.
Okay, that's case number 25-05477.
People coming up to the front. Let me take a look and see who they are.
Good afternoon, Your Honor. Sierra Oliver, P87707 for the defendants.
Got to turn down the high end.
Scheduled for a hearing. I do have a consent order for conditional dismissal. It says the case will be dismissed today upon the condition that the parties pay the past due rent due to a period of November 30th, total $4,974.63 plus court costs $222.28 for a grand total $5,196.91. That amount is accurate.
He just nods, Mr. Adidas.
Okay. As this defendant shall either pay the balance indicated in section 2D or vacate the premise on or before the 17th of this month. That's accurate as well? Okay, you both have the right to proceed to a trial, and you could have demanded a jury trial. Do you understand that?
Yes.
I'm going to move
And
up
you
to
want
the
to
top.
waive your right to have a trial in order to have this matter dismissed upon the conditions that I just read? Okay. And
We're going to skip ahead
you
just a
understand
tiny
that
bit.
partial payment will not satisfy this agreement, so you either have to pay the full amount.
We're going to skip ahead because it starts spicy at 6 minutes or the 6 minute mark. So right here. I'll be up here. Sorry, guys. I'm up top now if you're looking for me.
Your name, sir?
John Douglas, ma'am.
Your name?
Christopher S. Chastain.
Okay, today was the day scheduled for hearing for non-payment of rent. Did you all undergo a mediation?
We talked, we didn't come to agreement, Your Honor.
Okay. This is for non-payment of rent, correct?
Yes, ma'am.
And how much do you believe that they owe?
It's another month now, so it's about 3,700.
Not about, so this is support. And how much do they owe?
3,700.
How much is their monthly rent?
1,200.
Last time they made payment?
Yeah, you need these facts if you're going to court.
August.
How'd you get to 3,700? It's an odd number if it's
Do you
1,200.
agree your rent is $1,200 per month?
Yes, Your Honor.
Okay, and you believe you have a lawful reason why you haven't paid?
Yes, Your Honor.
What's the lawful reason?
Honor, I paid first and last month's rent and a security deposit. My initial lease with Mr. Douglas on October 1st of 2024. I signed a 6-month agreement for a lease. After the 6 months, my power of attorney, my daughter, who was also my counsel, I requested, as I continued to pay April, May, when we got to June, I asked her to contact Mr. Douglas to see where we were going with the lease, assuming that my other 6 months of my original year would be, talked about or settled. He presented at that time a June lease for 1 year. I amended it once I received it to show that I would prefer to have it to complete my 6 months, which would end at 8/30/2025, with September being the last month rent that I prepaid in October of 2024. And this is why we stand before the court today.
You signed the lease and you moved in, you said in October 2024?
It was a 6-month lease.
Your rent was $1,200 a month?
$1,200 a
The
month.
lease was for 6 months?
Correct.
You were supposed to, the lease ended when?
It would have ended March 30th. I believe that would be the 6-month period of 2025.
When it ended, did you move out?
No, I did not.
Okay, so then you went become month to month, correct?
That is correct, Your
And you
Honor.
paid your rent every month?
That is correct, Your Honor.
Okay, and then in June, you got a new lease presented to you.
In June, I had a lease presented to me through my power of attorney who represented me.
I
Do
don't
you understand?
I recognize you have a power of attorney, but they don't represent you in this court, so I'm asking you a question. You got a lease from him for, in June to re-sign a new lease for 1 year.
Correct.
From June to June?
From June 2025 to June 2026, correct.
Okay, but you didn't want to do another year, you wanted to do 6 months.
I wanted to complete my 6 months. That is correct, Your Honor.
Well, I don't know what you mean complete 6 months, because you didn't have your month to month at this point.
Correct.
You wanted to, instead of having a year lease, you wanted to enter into a new 6-month lease. Correct?
Correct.
Okay, and you altered or changed the terms of the lease and sent it back to him to agree to?
Correct.
And did he agree to it?
He presents now to court that original lease, I can't say.
Where's the lease that you signed that for 6 months?
This is my original lease
The original lease that you signed in 2024 is what you're talking about?
2025, if that's what you're asking for.
No, I want to know about the 6 months lease or the lease that he sent you this year in June. Do you have a copy of that lease, sir?
Yes, ma'am, I do.
It's getting spicy. Bailiff just has like a some college hoodie on, I guess.
You're up. Matt?
You may. Okay, so I have here what it says, it looks like a lease between Christopher Chastain and Christopher Chastain, the second or junior?
Junior, yes, ma'am.
correct? Okay.
Junior, John, I'm sorry.
Got it. Was the rent raised to $12.30 or is this $12.50? Is that what this says?
The rent is $12.50, but if you pay on time on the first, I'm gonna charge you $1,200.
Oh, I see. It's the discount of $50.
It's discounted $50.
Okay, so it says 6/1/2025 to 6/30/2026, 12 months. It looks like we acknowledge the sum of $1,200 for a security deposit, other terms and conditions, and it says that it was signed by you. What date did you sign this, sir?
I signed it on June 1st.
Okay, and then after you signed it, you sent it to him?
Yes.
Okay, so you were not present when he signed it?
No,
What did you receive back from him?
I got it. His daughter sent it to me.
What did you receive back? Because I don't believe it was this one.
That lease
I don't,
there,
I believe you got
that
this
page
sheet.
right there. I just sent her.
I believe you got this page. I don't believe you got these other ones. I believe that he changed it. What did you get back?
I don't understand what you mean.
He said that he changed the dates. Let me see what he has. To make it 6 months.
You got rid of his changes.
So he changed the dates on here supposedly to make it 6 months so that it will go from June 1st. This is not 6 months though, to September 30th.
I didn't give him permission to change those dates.
I didn't get into that.
Okay,
I'm just
sorry.
asking you what you
I
received back.
apologize.
Yeah,
I
I'm asking,
apologize,
what
John.
did you receive back from him?
I received back for the year. But only thing, see, Your Honor, all I did just sent him the last page. I told him to keep the first page from the year before. So the only thing I sent him just the last page of the lease to sign it and mail it back to me.
Oh, okay, is that correct?
Would you repeat that, Mr. Douglas?
He only sent you the last page to re-sign. He didn't send you.
I gave it to his daughter, Your Honor. Excuse me, I gave it to his daughter.
So you're negotiating this with his daughter?
The lease?
Correct, you gave it to his daughter?
Yeah, because I would never call him. He never talks on the phone. I never
Okay.
get him on the phone.
But I'm just asking you a question. I didn't
Yes,
ask you
ma'am.
why.
Yes, ma'am.
Okay, so you were dealing with the daughter. You sent her the last page and said to.
Have him and his son sign it.
Okay, why would you not send them the other pages? Because
They already had the other pages. So
They couldn't have the other pages that had June 1st through June 2026 if it's a new lease.
Well, I must have sent him the whole lease then. I mean, because.
Story changed. Uh-oh.
Doesn't sound like you know what you sent them. What's the daughter's name?
Tara.
Tara, she's got to come up now.
Step right up, ma'am. You might have to take whatever's on your head
You can
off.
stand right there, ma'am. No, you can stand right next to your dad, I mean. Okay, raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I affirm.
Thank you. You're familiar with the landlord, correct?
Correct.
Okay, and so he sent you a lease on behalf of your father?
Correct. He hand delivered it to me on the premises.
Was it one page or a full page?
He gave me one full lease and then an additional lease of the first page and the last page that had 4 John. So that was what I was to give back to him with the first page and the last.
Okay, and so the lease was signed and sent back to him?
Correct. After we amended it.
Okay, you amended it based off what?
Based off, we had a 6-month lease from October to, well, it was a 7-month lease, the way he wrote it, till it ended on.
Wait, who wrote it?
4/30. Oh, I had the original lease as well.
The way who wrote it?
The landlord, the plaintiff.
Okay, the original lease is what you're talking
Right,
about?
that we entered into October 2024.
Okay, so there was a 7-month lease that expired in June?
So it expired April 30th.
April 30th,
Yes.
okay. And so then June is when you're getting the new lease?
Correct.
And so when that lease came, the terms that he put on there was for 1 year?
Correct.
But you and or your father changed it?
Correct.
Did you notify him or give his permission to change it?
Yes. When he hand delivered the lease, he was coming to cut the grass.
Whoa, whoa, whoa. We just got news of a verdict. Hang on one second. Hold, please. We have to play the music. We have to play the music. Three and a half hours of deliberation the jury took to figure out something that the defense lawyer already knew. And that is that the defendant was guilty. This is a case of two young kids getting messed up in drugs they should not have been using. It took their lives on a path that no one could imagine, especially their families. Ended up in the loss of life of the girlfriend's grandmother, and they went on the run after stealing guns, money, and drugs from the apartment, as well as jewelry. They used friends to negotiate rides, paying with both guns and drugs, made it all the way to Laredo before they were captured and brought back in. This one was basically sealed by the words of the defendant himself, who kept a record of everything on his Instagram and text
And at
message.
this time, I will ask the foreperson, have you reached a verdict in this case?
Yes, we have.
Is that verdict unanimous?
Yes, it is.
Please hand the verdict sheet to Deputy Flynn.
Sir.
Only 8% of us were correct on the jury deliberation time, being between 3 and 4 hours. Between 2 and 4 hours, sorry. Question is, are they going to find him guilty of capital murder or just murder?
Mr. Urick, please stand.
State of Texas versus Uriah Lee Urick Jr., clause number 25 CR 0515. We, the jury, find the defendant, Uriah Lee Urick Jr., guilty of the felony offense of capital murder as charged in the indictment. Signed by the foreperson of the jury.
That means it's going to be guilty of
Mr. Ayden,
robbery
would
as
you
well.
like to have the jury polled?
No.
All right, you may be seated. So, ladies and gentlemen, at this time, your service is complete. I'm going to ask you to walk back with Deputy Flynn, and I'll visit you in a minute.
All right with you.
The minimum on this one is life without parole. There's no pre-sentencing investigation needed because unless this is a death penalty case where they can
At this
determine between the two.
time, may I see the attorneys, please?
Judge asked for a sidebar. Very little emotion from the defendant, who still appears to be writing as he has been throughout this trial, keeping notes for a book. I don't know what, but this flat affect we've seen from him matches what we heard when he called his mom when he was first picked up in Laredo, and we heard a jail phone call of him speaking to his mom, where he said, "There were choices, but in the moment there were none." Going to see if maybe any family are going to be speaking before sentencing. Sentencing may happen right now. Mr. Urick's girlfriend, Tara, is scheduled to go to trial on this same charge, the capital murder charge, in January. And he's gone. Not sure where we're going with this now. Judge stepped off the bench. Well, we might be done. It was guilty of capital murder. To get to capital murder, it had to be guilty of murder while in commission of the felony, which was robbery. So capital murder means, yes, robbery. It wraps into one. And that's it. That's the end. We're going to jump back. I'll keep an eye on court for right now, and if they come back with anything else, if the judge has something she needs done or is going to address something further, we'll bring it back to you. But in the meantime, we're going to jump back to this somewhat spicy landlord-tenant eviction situation that we had on going on down here.
All right, so it would be 2 6-month leases. So it'd be more punctual and consecutive. He interrupted me and said he signed off on whatever I put down. So I was explaining it. I'm like, as I started to explain it, he was getting ready to cut the grass. So I presumed he was in a rush. He said, whatever you put down, I'll sign off on it.
So essentially, your position or your father's position is that you wanted the lease to end on the 30th.
Correct.
Of September.
Mm-hmm.
Is that a yes?
Yes.
Why hasn't the rent been paid, or has the rent been paid since August?
So the initial October 2024 lease, we paid first month rent and last month rent and security deposit. And my father vacated September 17th, 2025.
Oh, he vacated September 17th.
So I have all the payment records showing that we paid first month rent, last month rent.
Where is Mr. Chastain's the second or junior? He's still in the property?
Yes. It was our understanding that his matter is a separate matter. He failed to show up at the pre-trial.
No, that's not what I'm talking about here.
Gotcha.
I'm talking about the whole concept that your father vacated, and so thereby he's somehow not responsible. Did they both vacate in September?
No, just my father.
But they're both on this lease, correct?
Correct. My father is listed as a tenant, and my brother, to my knowledge, is an occupant, an additional occupant.
And why didn't the brother vacate when the father vacated?
At that time, my brother was in contact, to the best of my knowledge, with the plaintiff, and the plaintiff stated that if he paid September rent, then my brother could stay. But since there was a dispute about September rent, since my dad vacated,
you guys missed the verdict.
We wanted to resolve September rent. And
you guys missed the verdict.
Got it. Okay. Yeah. And so your property is still occupied by Junior?
I haven't been back over it because I didn't know when the man served his son, he said his son was very angry. He was saying bad things about me. So he said that you probably don't need to go over there. You just stay away from over there and wait till you go back to the court. But Your Honor, I got something that I wanted you to see that she texted me about this rent situation.
Okay. The son was served
in
September?
Son was served and the son gave it to the dad, but the dad wasn't there.
That's not my question.
I'm sorry, ma'am.
The son was served in September?
You can rewind about 5 minutes and get the full verdict. It was very quick.
I'm not good at court stuff, Your Honor.
I'm not good at court stuff. We see that, sir.
He was served right here.
September 18th?
Yeah.
It said that you delivered it to him personally.
Me? I had a guy
Is your
serve.
name John Douglas?
Yes, ma'am.
You signed this proof of service.
Yes, I did.
It said you served him I personally delivered it. You signed this.
Yeah, I did the first time I did.
So what are you talking about his son? It says on the 18th, you served his son. So what do you mean somebody told you that he was upset?
Then after that, when the court went to have them for the eviction thing, the guy went to give him the eviction notice. He was the one that gave him the paperwork
notice?
To come to court. When you get him served, to come to court.
That was when you served the demand for possession, or are you talking about there's another proof of service?
This guy on here served him the paperwork right here.
Okay, so someone else served the summons, and that's the person who told you that the son was upset.
Yes.
So you knew then that Senior was no longer in the.
I didn't know where he was because I've been trying to talk to this man for 2 months and they would never let me talk to him.
Okay.
I didn't know where this man was.
Okay, and did you ever have an agreement with the brother, with the son
No,
about him
never.
staying in the property?
Nothing, never said anything
Okay,
to him.
what is the text messages that you want to share? Did you show them to the other party?
I showed them to him when we was here the other day.
Okay. And so what are these?
It's about the rent,
Tell me what I'm supposed to be reading.
She sent me a text and said, well, we changed our mind, we want to stay here for a year. I said, okay. She said, send me another lease. I said, you don't have to, I don't need to send you another lease. Just take the one you got and put the date back to where it was. You see what it says? She said she wanted to stay for a year until June. Because originally I told her I don't do 4 month lease. The last lease I would give you would be 6 months.
Becca, we just followed it. It was very quick. You
say
have to
something,
rewind
Give
about
me a
10
moment.
minutes
Okay.
to watch it. We did follow the verdict. We caught it live.
Okay, I have what purports to be a message. You're Tara, correct? Correct. It says amend the Highland Street lease to 1 year lease and mail us a copy. Thank you, Tara. He responds. That was on July 9th. Looks like there was the next communication wasn't until August 2nd. August 2025 rent for Highland in the mail. And it says T. Chastain, which I'm assuming is you, Tara Chastain. Right. Then on August 3rd, he responds, I'm assuming is Mr. John.
I talked to the phone, that's John Douglas.
Got it.
I talked to the phone.
Hello, Tara. This is John Dan. How do you change that lease from before? Just take the dates and change it back, and I'll change my dates. We don't need a new lease. Thank you. Goodbye. Your response sounds like a plan. Have a wonderful day. Why are we here?
My dad vacated in September.
But you agreed to a lease for a year.
So I did so under duress, Your Honor, because at this point.
Judgment in favor of the plaintiff. There was no duress.
Well, September.
There's all kinds of flower emojis, smiley faces, flower emoji, sunshine. No duress.
What about September rent was already paid?
No duress.
Can we say September?
All I know is that you agreed to a lease. First of all, you don't have a right.
Hold on. Hello? I tried. Hang on.
To change a document that was signed by the landlord without their permission. That's not how
He gave permission verbally.
That's not what he said. And I don't have anything here that would corroborate that. Not only that, this text message on August 3rd is pretty much how did you change it in the first place? He was not made aware. When you enter into a contract after someone has signed it, you don't get to change it and then expect them to have knowledge that you've changed terms. The other thing is, I don't know the nature of this power of attorney situation that you got going on, or why he has a power of attorney, because it sounds like he can handle his affairs on his own, is what it appears to me. But this creates additional layers of confusion.
There are reasons to do
that. The other thing is, the lease is not just for Mr. Chastain, it's for him and Junior. So he can't just vacate and leave his occupant there. That means he's still holding possession of the property. I don't see anything that there was a new lease. I don't see anything that there's a new text message where we know, or communication where we notified the landlord, we're vacating, and per your agreement with Junior, you all can move forward. I don't have anything.
I have something.
You have what?
We did send a notice of intent to vacate in August, and also sent a response to his demand for possession and non-payment of rent. I sent a response to him stating that if he chooses to continue with Chris Jr., it will be under the terms of a new lease. The only reason Chris Jr. stayed in the premises is because Chris Jr. was under the impression verbal.
You can't speak on behalf of Chris Jr. He had to be here to speak on his own behalf.
But I do have a notice of intent to vacate that was dated August.
That you sent after you said that you wanted a lease for 1 year.
Yes, dated August 29th, correct. And then the response.
You can't break your lease. Sure, you can't ask for a lease for 1 year and then break it. And you were presented a lease for 1 year. You don't get to, the tenant doesn't get to decide, well, I'm gonna do a lease for 4 months instead. That's not how this works. If you want that
Preach,
level of
Judge.
control, you need to be a homeowner.
Even if it was, we gave them a verbal notice that like, we had the intention of vacating in September and we did, or my dad did, I guess.
I don't know what you
That's
mean.
just
And also
announcing
there
you're
were-
You
breaking
mean
the
that
lease.
when you were presented with the lease, you had intentions of vacating?
Right, when he presented
What are you pointing to, sir?
It says you must give me a written notice, 30-day notice in writing.
I did.
Okay.
But can I say something?
So wait a minute. So I'm trying to clarify what she's saying. What you're saying is that when your father was presented the new 1 year lease, you're saying that there was plans for him to vacate in September?
Correct.
So why would you send a text message in July to say, we'll take a 1 year lease, mail us a copy, thank you, smiley face?
Because he sent me a voicemail saying he couldn't do the format, he rejected the lease that I presented to him. So at that point, I'm like, okay, he didn't remember saying I could sign off on anything, and I
If he
didn't.
rejected the lease, then then that means you're still month to month and you could put your notice in.
Yeah, and
But the problem is you now ask for a 1 year.
But my dad didn't. Sorry, go ahead.
may I clarify?
It can't be I'm the
Yeah,
power
yeah,
of attorney
yeah.
and then now my dad did. You can't do that.
Well, I'm saying it
Yeah.
wasn't a meeting of the minds. Go ahead. I'm sorry.
So I apologize. John.
Yes, sir.
For clarity purposes, why it was worded that way, 6 months original, and another 6 months was the year, which was trying to be.
I'm completely clear on what you wanted, sir. I'm completely clear. What I'm saying is, when he presented you a new 1 year lease from June to June, neither you nor your daughter have the authority to alter the terms of that lease. What I have here that your daughter has presented, there's whiteout all over this, okay?
Sloth Life,
This
yes.
is the original.
We had the verdict.
Where did you send him?
Not my writing, man. That's not in my hand.
No. What did you send him? Because this is the original.
Yeah, I amended it.
Yeah, but what did you send him then?
I sent, he gave me an extra copy of the first and last page, so I amended both documents.
Oh, yeah,
And
and sent it back.
Yeah.
And so his communication that I have here is he wants to know, how did you change the lease dates in the first place? He doesn't agree that he gave you authority to amend and do that. And you wouldn't have authority to do that.
Okay.
And so if you wanted to negotiate a new lease, then that's fine. He would need to sign off that he's okay with amending this. I've never heard of a 4-month lease. And so you were month to month. You don't get to now.
We could have stayed month to month.
You could have stayed month to month.
Okay.
Or you can enter into a new lease agreement.
I did ask
You
him.
tried to enter into a 4-month agreement. He rejected, and your response was, okay, we'll take a 1 year lease.
I did ask him if he
You could have
go
stayed month to month.
I did ask him that at the time, and he said, put down whatever you want, and I signed off on it.
He doesn't agree that happened.
I even in after the original lease of October, I sent him a addendum to renew the lease, stating that we wanted a month-to-month lease.
Well, you were already month to month then.
Okay.
And you could have stayed month to month. You could have communicated, we want to maintain month to month
Yeah.
because we want to move out September 30th.
Yeah.
So I apologize.
Yes.
So I had the right to continue the month to month and not have to inquire his preferences of years or 6 months. That's where this confusion came.
Well, I don't know if that was necessarily his preference because you had been living there for a couple months without a lease. You
Right.
were already month to month.
And
It sounds like you wanted a new lease.
I inquired for him, his preference of year or 6 months. I hadn't heard from him.
He said he hasn't heard from you. So there's obviously a communication breakdown. And then you have your daughter sometimes handling your business.
Well, for this property, yes, I do at all times. So
Well, then you can't, when you're saying you inquire, I don't know if that means you reached out to him directly or if your daughter, I don't know what that means.
yeah, I asked her to reach out because I was confused as to where we were at, not thinking he would allow month to month, which I was paying because the 6 months had expired. First month's rent, last month's rent, and a security deposit.
Okay, and he was allowing it. I don't know. He's represented in this court that you all were friends long before this, I'm assuming. And so maybe he would have allowed you to do month to month to September. I don't know. That's not for me to decide. What I do know is that we have a situation where a lease that was altered after he signed it, and you can't do that. And then I have some communication where you, and I don't have anything prior to that where it's, you know, it tells me that you all were talking before this. I just have where you request very nicely to amend the lease to 1 year. And his response is amend the lease. Like, I never changed. How did you change it in the first place? Just go back to the original and fix it back.
I thought we had to be in a lease, which is why I responded. I didn't know we had the option.
Either way, you said it sounds like a wonderful plan. You did not appear to be in any duress. And then your father has maintained this property and then left his occupant in that property. And you say you sent a notice of intent to vacate? Mm-hmm. When did you send that?
August 29th.
Did you receive that?
Yes, ma'am. Can I say something?
Yes.
I didn't get to know. She sent it on, but I didn't get to like the 6th or 7th that next month. You got to get it on the 1st because I got to give 30 days. She sent it after the 1st. She should have sent it. She might have mailed it on the 29th, but it has to be to me by the 1st, ma'am. It does, young lady. You're a beautiful young lady.
Sir, that's not appropriate.
You're a beautiful young lady. Don't talk to the other side.
So you
talk to the
received
judge.
the notice that of his intent to vacate. Let's see, tenant, senior. It only says senior.
Karen and
I don't know
PA.
why we're not addressing
Your recovery addict mug just arrived.
your
Today,
brother
just now.
in this. For some reason, you believe that there was, and you said there was another communication about your brother.
Oh yeah, when he presented the demand for possession,
which was after this.
Yeah, I responded, and to my understanding that agreement, you know, we were making an agreement. He gave me verbal permission. I didn't get it in writing that I could, you know, amend the lease to our preferences. So when we got the notice of demand for possession, we was confused. And so my brother did want to stay, and to our understanding, I just responded to that. Said, you know, that my dad off this lease and come to a new lease agreement with my brother so we can start in October. Last September be my dad's last month, which we prepaid the last month.
That sounds like negotiations that you were trying to do after the eviction was started, which could have happened. Mm-hmm. Your brother never came to court.
Yeah.
He's still on the property. I don't even know where he is.
Is he still there? I don't know. I ain't been over there.
Well, at this point, you could have defaulted him a long time ago because he failed to appear.
Well, you know, we grew up. I consider him like my family still, and I didn't want to put I don't know if his son had anywhere to go. I didn't want to put that man out on the street until we got this straight.
Well, you consider him like your family. You want to put an eviction on his record still?
Didn't get my money.
We gave him September, and I do have evidence of September. So October would be the new, in my opinion, October will be what's in question. If my brother is still in the property.
The brother's still in the property, we think.
Well, I'm gonna have to do the next step to get him out then. If they don't, unless they want to start paying my money and stay, I don't care.
Okay, all right. Unfortunately.
Show me the money.
The default is entered, so you can, when was it entered? The first free trial. Yeah, so you can get a judgment so that you can have the brother removed at this point for his failure to appear in court. And then there was a file for money judgment. I have the thing here.
Can I say something else to you?
Oh, sure.
Okay.
There was a money judgment filed. Yes.
We have a rental.
I was calling her dad one time to try to get him on the phone.
For nurses, traveling nurses.
And he didn't answer. So me and my girlfriend said, I know you're monitoring your dad's phone. And she texted me back. And then she gave me this big, long text on my, well, you can let my brother move in. He gets Section 8, he get $800 a month. Maybe you should drop your rent to let him stay here.
Okay, what evidentiary value is this story for me, sir?
It's on my phone.
No, I'm trying to figure out what you want me to do with it because I've already given judgment.
Why are you telling me
I
this?
feel like she just abandoned her brother and kicked him to the curb. I just left
She
him.
abandoned her brother?
Just left. She know he can't. He can't afford that building.
Why is she responsible?
I feel like she took her dad from her brother and took him out of the house.
She took her dad from her brother.
That's how I feel. I might be wrong.
How old is this young man?
He's 40.
Yeah, 40 something.
Judgment in favor of the plaintiff.
So
we're not responsible for our grown brothers.
Okay.
So is this a judgment against my dad?
There's a judgment against
for September rent or
exactly because the rent has not been paid.
September was prepaid. I have
there's first, last, and security that you received.
Right.
And you acknowledge it in there. but it's now November.
Today
That's
I pay
the issue.
November.
Okay,
So
so it's for October rent.
October and now November.
Okay. So it's two judgments, one against my brother.
He's already been defaulted, correct. And now there's a judgment against him. Money judgment is a little bit different.
Okay.
Because the brother is still occupying the property. He did move out in September. And you have a new lease, sir?
Yes.
Do you have proof of this new lease?
Digitally, yeah, when
Visually, yes.
digitally, Your Honor. But we can present paperwork after court.
If you have, I would like to see the copy of the new lease. Just to.
Guess she's gonna
be
just
sure
walk
that
up.
he has.
Apologize, Your Honor.
No worries.
Is that the brother back there that they're just not talking to? We have a rental with that we rent out to traveling nurses. They're the best renters. Let me just say, they're the best renters. They get paid very well, so they're good payers.
You can have some time to look for what you need. I'll take the next case, okay?
All right, thank you.
They're on contracts.
Okay, this is Aspen Flats versus Sherry Armstrong and any.
We're gonna jump. They're on contract, so they know how long they're going to be there. Everything's up front. They pay very well. They sleep and they work. That's what they do. They sleep and they work. And so it's awesome. We've got a renter right now that's in for 3 months, possibly going to extend for another 3 as the contracts extend. And for us, it's been great. But I watch some of these and I'm scared. I see the horror stories. But we actually took the listing down off of Airbnb because we did get a couple renters that were like, oh, that could have gone really bad. So just for a confirmation for those who missed it, it was very quick. After 3 hours and about 29 minutes, so 3.5 hours of deliberation, that includes lunch. And we know this jury likes to take a long lunch. The jury in the Uriah Urick case came back with a guilty verdict on the capital murder charge, which carries a minimum of life without parole. And immediately the judge basically just got up and left. I don't know if there's going to be anything else from that courtroom, anything that's happening. They're still running a live feed from court. But I think it's just the cameraman milking the hours to get a little extra time up. So I don't think we're going to see anything else out of this one. Which means it takes us all the way to the weekend. No hanging chads, so to speak, legally speaking, with cases that are just about to resolve. That means we get to pick up a new one on Monday. I can't announce where we're going yet because I don't have it quite sorted out, which means I've got work this weekend and you guys can take it easy. Also, there is a slim chance, I say slim because our car's still in the shop, a slim chance that we're going to be going on doing a little live streaming tomorrow with some metal detecting at the ocean. Haven't done that in a long time, but I have to take the door that somebody was nice enough to shoot out in the front of my house, thank you, whoever that was, and get it replaced with some tempered glass. And the only place that does that around me is an 1.5-hour drive away, and I have to take the door to them. Check mod chat. I'm checking right now. Oh, they might be coming back for sentencing. So we might be waiting. Hold, please. Hold, please. If they're going to do sentencing here, then we're going to stick around for it. So we're just going to chill. If Judge Middleton is up, I might want to chill with his courtroom. That's a fun one to go visit. A little spicy. A lot of landlord-tenant stuff going on today. Some of my favorite other creators that are not LawTube oriented dropped new videos today. Arms Family Homestead, Daniel Arms dropped one. Luke McFadden, my favorite crabber out of Maine, or Maryland. Sorry, Maryland. He dropped a new one. Let's see. The Bama Bass Pond. That's out as well. Friday's a good day for videos. It gives us something to watch over the weekend. Let's pop in Judge Simpson's if we can. Let's see what's happening down there.
Okay.
Okay.
So I get that. And so before they can do anything, they got to come through me.
Okay.
Got it?
Okay.
You trust me?
We're still monitoring. We're
I
still
want
monitoring
to.
Texas. We're still keeping an eye on this.
But yes.
When they come
All
back,
right.
we'll jump there.
But that's what I'm going to do.
Just scary.
Okay.
I've been there before.
But before they can do anything, we got to have a hearing. And I put it in file, no writ without a hearing.
Okay.
And it's on the judgment form. You'll see it there.
Okay.
Okay?
Okay.
I just emailed Ms. Atik, Kara Painter from SOS, and copied Ms. Whiteley, giving them the numbers and the.
Okay, did you hear that?
No.
Okay, so Mr. Fink sent over the judgment and everything to some individuals at SOS and Hawk and the county so that we could try to get that process started. But I need you to still call down there.
Okay.
All right?
Okay.
We won't leave any stone unturned, Mr. Herrera. Okay?
Okay. Thank you.
All right. You have a good weekend.
This just means we have to sit around and wait for the judge to come back in Texas, and we'll
Peninsula
do that
Place versus Andrika Underwood.
to get the sentencing.
Anything for the plaintiff.
This judge does have a soft spot for the tenants. Understands a lot of people are going
Hello,
through hard
your name?
situations, but
Andrika.
the law is
Okay,
written for
where
the
are we at?
landlords. Almost always the law falls on the landlord's side. He'll push things off as long as possible, but there's an inevitable.
Yeah.
Good approach. That means it goes off camera. Judge Simpson, one of our favorites, not without controversy, but a good judge. I just realized I did did Judge Teep a dirty pause here when we left him. I left him right like that. Sorry, Judge. We will be going back to Texas as soon as the judge comes back in for sentencing, which might be any moment now. Let's see, there was a tenant a few weeks ago that told Judge Simpson that he was going to piss her off. Ooh. He's had some spicy ones. AWOL says, I'd like to do a poll to see how many people here have debates in day-to-day life. Like with themselves or with someone else? Because I think I do both. I do both. Judge Simpson is a sweetheart if you don't rile him up. Yeah, he doesn't like being lied to. He doesn't like people just yanking the court's chain. I don't debate people as much as just inform them when they're wrong. AWOL, is that also count? Doesn't like defendants trashing their lawyers. He's got some good lawyers to operate there. Still at sidebar. His camera came on. Oops. Cats win every debate they ever enter. That's by default. It's in their nature. That's not a debate. That's mansplaining. I never tell Mrs. R.A. that she's wrong. I've learned that is not good for my health. And generally, I find out that I'm mistaken at a later point anyway. So if debates are done with calm voices, then okay with me. I like rational discussions. I'm not a big fan of debate back and forth just to debate. If you both go in there to prove the other person wrong and that's the only thing on your mind, it's generally not a productive conversation. If you go in there with an opinion and the ability to listen.
No, hold on a second. Hold on. I'm not done yet.
Come back up.
Your Honor, the totals are 4929.98. The costs are 250.
It's $5,000.
This is a possession and money case. So the total is 5179.98. I have authority to agree to the redemption date of the November 30th.
It's a lot of money.
I'm going to issue judgment for possession, finding no tribal issue for that amount. With the writ date, actually, will be December 1st, because it has to be a date the court's open. Right. So that's what I'm going to do. All right, young lady, good luck to you.
Thank you.
Yes, I saw this. Yes, she's threatening to sue the neighbors.
Court calls case Peninsular Place versus Christine Richter.
Okay, thank you for the plaintiff.
Your name, ma'am?
Christine Ann Richter.
What are we doing?
There's a written hearing.
Yes.
Doing possession and sort of the balance is the same as the Jackson amount.
Ma'am, have you paid anything on this?
I did last week, the 750.
How much?
750
Last week?
was, yeah, I believe so. Because I failed to show up on the Zoom meeting. I didn't quite understand. It was my first time, so that's why I'm here, I guess. So I paid 750, and then I really don't know where I'm at right now. Like,
I don't see a $750 payment, and
I paid it here.
Oh, hold on. She did.
In escrow.
She did. I have it. That's why. I believe you. I just like, if he didn't see it, I'm like, what?
Right.
And so I got it. When you said you paid it here.
Judge, the judgment that was 2920, today's balance not calculating in the money you're holding is 3826.98.
It's what?
3826.98.
So you're actually at about 31.
31 minus 750, right?
Yeah, if the 750 comes off, you're about right there.
Yeah, so can I get an extension until the end of the month? Only because my clients, they pay me every end of the month. So I have monthly, I don't have a job. Like I, run a home care and they pay me every end of the month.
End of the month. I got you.
Yeah, so I don't, and then if, every time if I have to do that, then it takes 2 to 3 days to clear the check. And the last time I was supposed to pay, I had to send money to the Philippines.
Gotcha. Okay. Here's what I'm gonna do. This is your motion to set aside the default. I'm gonna deny the motion, right? Escrow will be paid to the plaintiff, and that will get applied to the judgment amount. So what I'm doing here is rather than work with what you owe for November, I'm going to leave the judgment in place because that happened in October, and that's the amount that you have to get. Okay, so it's 29. It was at 2920. Can you do some math? Pardon?
2920.12.
Yes, and 12 cents. And then 2920 minus 750.
$2,170.
2,100. Okay, so about 22. So what I'm doing is we're going to use that number. So I'm not even including any of November. Okay. So I'm going to deny your motion. That's the number you got to work toward rather than have your November click in. 750 will come off of the 29. So I'm going to deny the motion, but then I'm going to indicate that Rick may not execute prior to, and I'm going to give you all the way through November if that's how you get paid. So prior to December 1st, which is the court's next business day.
Are you entering the writ that we submitted? Submitted on the 4th, looks like.
No, it hasn't.
Let me ask a better question, Your Honor.
I'm not
Do we
seeing
need to
Rob's
submit
placeholder
a
up
new order of eviction? You'll use the one we have. And
We'll use the one that you have.
Restrict execution.
Right, and execution, and it may even get signed before then, but it can't be executed prior to December 1st.
We're awaiting sentencing
Okay.
in the Texas case right here. We're watching that right now. We're just awaiting sentencing, and we're just watching some of our favorite courts in the meantime.
Get that in before the 1st of November. So as it's coming down toward the end, whatever they're paying you, get it to them so they can knock that balance down.
Yeah. The only reason I didn't get to pay is I had to pay.
Pardon?
The reason I was behind is because I sent money to the Philippines to my family. Because, they had a typhoon and earthquake and stuff like that. So.
And that's where your family's from?
All of them. I'm the only one here. And they all rely on me. And I send them money every month. So that's why I'm so behind.
Okay.
That's the way I was always been, compliant, but just because of, my family back home, that's why I'm behind.
I got you. All right. So we're going to give you that time. Okay.
Thank you. I truly appreciate it.
Ma'am, the most important, how's your family?
They're fine. My mom went to the hospital when today I had a Zoom meeting that I missed. And I had to send money again. I just keep sending whatever I have.
Okay.
And I work, 24 hours a day.
You don't work 24 hours a day.
So that's why. I'm sorry.
I get you. Okay.
I don't ever want to be late with, I don't even own a credit card. I don't even shop or anything. It's just, I'm all by myself here. I have no family or anything. I have a son who's 20, but other than that, I don't have anybody who can help me. So I'm the one who's helping back home.
I love that she's helping her family. She has
That's
to
why.
take
It's all
care of
gonna
her
work
first.
out.
Her
It will.
first,
It will. I'm working
so she
so
can
hard.
keep helping her
I
family.
really am.
And ma'am, I'm going to tell you, I don't doubt that for 1 minute. Okay. So when your clients pay in, and like I said, if they pay early, get it to them.
I
So
will.
we just knock it down.
There's one client that pays me bi-weekly. It's just one.
Okay.
The other two, they always,
It's monthly.
there's nothing I can do about it.
There you go. All right. But it'll get here on time. And if it's a circumstance where, let's say, the check gets to you on the 1st, call Mr. Fink's office or call the landlord. All right. And just tell them you have it. You just got to get it.
I tried to call them many times and they never responded. So I just figured, you know what, I'll just show up here. It is what it is, whatever the judge, decision. It is what it is. I'll just have to work through it.
What did she do for work?
All right. It'll work. We'll get it done. All right. You take care. Have a blessed weekend.
Thank you. Appreciate it so much. Thank
Works
you.
out for you, man.
Yeah. I'll just call your office.
Riverside Apartments.
Okay, we're gonna see if we can bail from those. See if there's anything else in the world of true crime right now while we wait for the judge to come back for sentencing for the Uriah Urick. We got a quick, very, very quick guilty on the capital murder charge, and now we're just sort of in a holding pattern. not knowing when the judge is going to come back and address sentencing, which might be today. The minimum he's facing is life without parole. So that's a pretty hefty sentence there. And because that is the minimum, there would be no pre-sentence investigation, is my understanding. Usually that only kicks in when there are options where you could have, 20, 40 years, 60 years even, and then be eligible for parole. But seeing a little bit of motion there in court, people walking around. We'll hold tight just for a second and see if, I think that was the court clerk. Looked familiar. So with him being there, that's definitely a good sign, because nothing can happen without him recording it for the record. Per Google, Texas life in prison is 40 calendar years. Is that the same for, would that be capital murder, life without parole, 40 years? Because then you basically get parole after 40. 13th Judicial in Kansas, we could see Mr. Laguerre. Let's see if he's there. 13th Judicial, Kansas. Let's jump down to Mr. Laguerre. We'll be back
to follow the recommendations of the drug and alcohol evaluation, attend a DUI victim panel, and any other orders the court may deem appropriate.
Mr. Patterson?
Judge, on the court's question, I would suggest that currently under the DUI statutes on a Class B misdemeanor, even as an adult, there's no mandatory 48 hours anymore. So there's no mandatory time in this case. It's just whether the court would order the 10 days or not. All the other requirements of a DUI, though, the mandatory fine, other items, drug and alcohol evaluation, those are required by law still, even for a juvenile. So we're not going to suggest otherwise to the court. The only thing I would bring to the court's attention is if the court does remember, last time we were here, he was in custody. And the court modified the bond at that time to release him to appear today for court. And that was his 10th day of being in the county jail, which would also mean that he has completed the sentence that's possible in this case. So I'm not sure, given those facts, the court can place him on probation at this point, since he has served this sentence. That'd be our position.
We've seen more motion in that court. I'll bring it to you as soon as they go live.
Any statement that you'd like to make before I pronounce sentence?
No, Your Honor.
Did you have any passengers in your vehicle when you were driving under the influence?
Yes, sir.
How many?
2.
No bueno.
Do you know their parents?
I do not, sir.
Ever met their parents?
No, sir.
Who were these people to you?
Mr. Overbay, have you ever had an occasion to see people that in person that have been killed in an automobile accident?
Your Honor, I have not seen that personally, no. I have.
You have what?
I have lost an extreme amount of friends here in even the past just year to automobile accidents.
Why are you driving drunk?
what effect, if any, has that had in regards to your behaviors?
Sir, I don't drive anymore. I haven't had my license, so I don't drive at all. I was at this time. It's just not worth it to put my life at risk or others. I don't drink anymore. It's illegal for me to, and it also puts my life and others at risk. None of it's worth it, and that's all.
Yeah, the judge basically, have you ever been at a fatal accident and seen the results of this? Trying to scare him sober.
I'm going to place you on probation from a controlling sentence of 10 days of detention. In the event that there's I'm placing you on probation from that. In the event that there is a challenge to that, or if there's a motion to revoke you, certainly there are arguments that can be made, but I think I do have the legal responsibility to sentence you in regards to these matters. I'm going to impose a fine of $750 court costs to you. As this is a traffic matter, that would be a traffic court cost. I'm going to assess the attorney's fees to you. I'm going to order that you go through the treatment that has been recommended at your expense. I'm going to order that you go through the victim panel. Mr. Overbay, I hope this is an isolated mistake that you made and not a course of conduct. Time will tell. And I hope that you never get to view or have to view what I asked you before in regards to somebody who has been killed in an automobile accident. Due to my profession, I've had to, and it doesn't, I don't think it leaves you. Probation will be for a period of 12 months. No law violations, and that includes if not to violate any your driving privileges in any way. This is a major mark on your driving privileges. I don't know if you've been watching other court from time to time, but these things, if you get 3 major ones, then you're subject to an habitual violator, where a person will lose their license for 3 years. It's difficult to get around and get to work in the state of Kansas without being able to drive. Counsel, anything further? I'm going to order that he contact court services. Court services, they have the juvenile as well as adults in the same one, so I don't know that makes a difference. I mean, it'll be the standard probation. You are not to use any illegal drugs or alcohol. You are subject to testing as they request, upon reasonable requests.
I think it's been about an hour since we had the verdict in the Urick case, waiting for the sentencing.
Counsel, anything further?
No, Your Honor.
Nothing further.
Very well. Good luck to you, Mr. Overby. You need to contact court services there in the courthouse. Following this hearing, they'll make appointments for you that you need to comply with.
Thank you, Your Honor.
Good luck. That matter is adjourned. That takes us to State of Kansas versus William Phillips. Mr. Phillips, if you turn on your video and your microphone, please.
Sherry and Max, thank you very much. 13 months.
Thank you.
This judge is very
Case
slow and
number
deliberate.
25 CR 386. Counsel state their appearances, please.
Jerry Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of William Phillips. Mr. Phillips does appear via Zoom audio visual. Judge would ask to have pretrial in this case set for February 23rd and a jury trial set February 25th, both in 2026.
So ordered. That bond or the that is at 9 a.m. on the February 23rd docket before Judge Webster. Respondent is to, let's see, he had issues on the past with appearing. I don't see any prior failure to appear, so he may appear by his own Zoom. Mr. Phillips, it looks like you're in a vehicle. Wherever you're going to be sure you have a good connection. If person doesn't have a good connection, that's due to the choice where they made to stop. If you're worried at all about your equipment or anything like that, you can. If the defense attorney will allow you to report from their office, that's fine. Otherwise, be at court security where that equipment is available. But it's important that you stay in contact with Mr. Patterson and that he have a way of contacting you. Mr. Patterson, do you need him to report to your office anytime soon?
No, Your Honor, we'll reach out to him and set an appropriate appointment.
All right. Mr. Phillips, you have any questions about what you need to do?
No, Your Honor.
Okay, your bond is continued with all the terms as before. Next matter, and
we're seeing people move around in the court more and more. So hopefully any minute now we're going to get the sentencing portion of the Urick trial underway. The verdict came in very quickly. It was 3 minutes from start to finish was done, and that includes the verdict music. It was extremely fast. Just waiting now for the judge to show up and proceed with sentencing. I'm not sure if there's going to be victim impact statements or if it's just going to be another very brief sentencing. The judge, a few remarks from the judge. Looks like that it appears to be a bailiff that's walking around. If bailiff's here, we're probably going to get the defendant soon as well. Hang on one sec. Gonna make a call, check on the car. Hang on, hold, please. We're waiting for sentencing right now. All right, Ms. Zari is going to check on the car. Is this death penalty eligible? Typically in Texas, I would say yes. Capital murder in Texas has two options, life without parole and death penalty. Because this is a crime because of the age of one of the defendants, particularly the girlfriend, we know she's not eligible for death penalty, but I don't know if they said on both, we're trying them as co-defendants and we're not going for death penalty on either. I don't know. I just haven't heard. It looks like the judge is, I can see her head right there. It looks like she's in court. We're getting some motion with the camera. We should have something in just a moment. Here we go. No audio yet. We'll get it as soon as it comes through. Might be waiting for the defendant. He's here. Just waiting for sound now. Adam, you were correct. Death penalty is also without parole. We typically just don't mention that part. Judge might be doing some paperwork here, just waiting for the case to be called officially. Mr. Urick has been just like this throughout the entire trial. I'm not sure if it's just resigned to his fate or what, but no emotion, almost no interaction with his lawyer that we've been able to observe, but part of that's on the cameraman, not necessarily him, so there might have been some discussions at times that we did not see. But
matter.
Here we go.
So I'm going to ask you to please stand. So, Mr. Urick, you came before this court and a jury and entered a plea of not guilty to the offense of capital murder. The evidence was presented to the jury. A jury was charged, and after deliberating, the jury returned a verdict finding you guilty of the offense of capital murder. Is there any legal reason why sentence should not now be pronounced against you? Any legal reason? Right. Having no legal reason, I see you shaking your head no, and that's correct. There's no legal reason, correct?
Correct.
All right. It is the order of this court that you, Mr. Urick, who have been adjudged guilty of the offense of capital murder and whose punishment is assessed at life in prison, that you be delivered to the sheriff of the Galveston County Jail, who will then place you with the director of the Texas Department of Criminal Justice Institution Division, where you'll be confined for the rest of your life in accordance with the laws governing the Department of Criminal Justice Institution. So you are now remanded to the custody of the Galveston County Sheriff, who will remand you to the custody of Texas Department of Criminal Justice. And any time you have will also be given to you. It appears that you have 272 days credit. That credit will be given. There's also going to be an entry of a finding of a deadly weapon, namely a firearm. Because you are indigent, I will waive your court costs. And because this is a plea bargain, because this is not a plea bargain, you do have the right of appeal. And I will take notice of the fact that you have indeed filed a notice of appeal, and the court will appoint an appellate attorney to help you.
Wow.
Anything further for the record?
He's already appealed.
Okay.
From the state now.
And we do have a dismissal for the credit card.
That is correct, Your Honor. I will say, Your Honor, the discovery receipt is still loading to be printed, and I will give that to the court as soon as it is done printing.
Okay. Anything further for the record?
No.
Okay. The proceedings are concluded, and the court stands in recess. Thank you. Here you go, Colleen. You go.
Wow. That was it. The judge gave the only sentence she could, I believe, in this case, because this was not a death penalty case. He will spend the rest of his life in prison, which we hear is 40 years. We waited for that. Yes, we did. But now we have the conclusion to that. And we also have the back of the prosecutor's suit. So there's that. Interesting. He spent those 200 some odd days in custody. He was captured 2 days after the crime and has been in custody ever since. This is a speedy trial. It happened this year, all in 2025. Remarkable. Most times when we're watching court, we're looking at cases and looking back multiple years, talking to witnesses who are trying to recollect what happened, 3, 4, 10 years ago. Not so in this case. It was just basically since New Year's Eve, all these events occurred, and the majority of that he's been in custody. So justice for Tammy in this one, and it's difficult to see a young person go to prison and throw their life away, but it was a decision that he himself chose. That's something that he made. I don't think this is a situation where we have any sort of injustice taking place, but hopefully some lessons learned, maybe for other young people who might be tempted to or experimenting, especially with drugs. I think drugs were very squarely to blame for a lot of the decisions he made in life, and even maybe some of the paranoia he was experiencing that drove some of his decisions. But there we go. Whew. All right. With that, it's 4:30. My son went camping without me. I was thinking about going camping with him, but he went on his own. He's with a bunch of friends. So I'm not going to go join him tonight. Also because we don't have a car. So there's that. Still in the shop, which means probably no metal detecting tomorrow. No door tomorrow. That pushes the door out another week. Yay. There's an option. I found a website that will actually ship me tempered glass in the size I need, but then I have to take the door apart and build it myself around the glass. I'm not sure if I'd know. I know I don't have the tools to do that. I definitely don't have the knowledge. But that would be cheaper for sure. Save us a few $100. But, yeah. All right, the weekend's upon us. You guys have successfully navigated the work week. It's hard to end with a downer like that, but justice was done, and I think that was the right decision. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. Monday morning is the next time. Monday morning. Hopefully we'll have a new case for you we can pick up and watch. We've been pretty good about keeping you back-to-back cases here, and we have a few that we can choose from, so we'll do some homework on this one, and we'll be back again on Monday. If you liked it here and this is your first time, please come again. Click the like button, subscribe to the channel so you can talk with friends after 5 minutes, and once you see who all's here, you'll never want to leave. So thank you all. Thank you to our amazing mods who make this the best place on the internet to watch true crime, and thanks to all of you who make this possible. I could not do this without you. You guys have a wonderful weekend. Be good to each other. Bye.
Thank you, sir. You're my new best friend.
Hello?
I saw a chicken fight. There's nothing in the order that restrains you from talking to cats.
Hello?
I don't like podiums, Your Honor. I like stolen as well.
Hello?
I was kicked back, taking it easy.
I think I'm about to catch a whooping. Hello? Hello?
You don't put a diplomatic plate on a hoopty.
Shame on you, sir.
Hello?
Have them send someone with more experience.